Okay, good morning and a warm welcome to you all for the CSET. This is your first class of law, right? Yes, so welcome to the first class of your business laws. My name is CS Rajesh. I'm a practicing company secretary. I've been teaching law for more than a decade now. I teach for all three professional courses. I teach for CA, CS, and CMA students. And for you guys, I'll be teaching business laws. As you guys know, business laws and management is of is a MCQ paper, right? Right. Out of the remaining all four papers, this is the one paper which is MCQ based examinations. Has two parts. Part one is business laws, and part two is management. So part one has a weightage of 60 marks in your examinations. And and for you guys, I'll be teaching the business laws. And you guys know how important the law is for a CS student. CS is all about the laws, right? So you should make sure that you learn all the basic concepts at the CS EET level so that it will help you guys in your CS executive level. Then there are three simple rules in my class. The first rule is you should always come on time. If the class timings is 8 o'clock, make sure to be in the class by 8 max to max 8:05. That's it. Then, second, make sure you guys do revise and come to the class. Revision is must. And the third rule is that you should participate in the class. Law is a subject where you need to deliberate and learn. It's not like you read something and you remember it and you write in the examinations. You need to deliberate it and you need to think in different perspective to have your own point of view for every provisions of the law. Got it? So you should cultivate the habit of thinking. That is what matters the most. And that is what sells in the market now. It is not like you learn something, you remember it, you write in the examination, you'll forget it. You need to introspect the provisions and need to go in detail and make your concepts clear so that you can build the advanced provisions at the CS executive. Done. So make sure you guys do participate and do ask questions in the class. And when I ask questions, make sure you guys do answers in the class. Done. Got it? Okay. So let's start with the subject. What is the subject name? First of all, business laws and management. Business laws and management. What is the weightage of the paper? 100 marks is the weightage of the paper. So in this, it has two parts. Business law has a weightage of 60 marks in your examinations, and the management is having a 40 marks weightage. What's the weightage? 40 marks, 60 marks, and 40 marks. And this is an MCQ pattern examination. This is the only paper which is based on MCQs. Done. So, business law has how many chapters? Sorry, it has a weightage of 60 marks and it has six chapters. The first one is Introduction to Law. Introduction to Law. In these, you study about what is law, the sources of law, why the laws are made, precedents and judgments, and you also study about the hierarchy of the court. In the chapter number one, about introduction to law. Chapter number two is about elements of company law. Elements of company law. In these, you study about company, the basic concepts of Companies Act. What is a company, types of company, the features of company, about the board of directors, and about the shareholders as well as the shareholders meeting. Done. And the chapter number three, elements of law relating to contract. So in this study about the Indian Contract Act 1872, one of the important chapters. This every student, whether it is CA students or CMA students or CS students or BCom students or MBA students, everyone studies this chapter because all the transactions, most of the transactions in our practical world based on the what? Contract. Recently, Trump signed a deal with Iran. That is also a contract. So every student study this Indian Contract Act, one or the other levels in their curriculum. And we will discuss about what is contract, who makes the contract, how the contract can be made, types of contracts, special contracts, all those things we will discuss in the chapter, the law relating to the contract. Then we have the fourth chapter. Fourth chapter is elements of law relating to partnership, relating to the partnership, relating to partnership and the LLP. So in these, we will study about what is partnership, who are the partners, rights and duties of the partners, and all other aspects we will discuss in detail. And we also discussed about few concepts of limited liability partnership act. Then we have the fifth chapter, that is elements of law relating to sale of goods act. Sale of goods act. This is the one more chapter where we discussed about what is a sale, what is a contract of sale, who is seller, who is buyer, what is the difference between sale and agreement to sell, conditions, warranties, transfer of ownership, and when a non-owner can transfer the ownership in the goods. So all those things we will discuss in the sale of goods act. The last one is elements of law relating to the negotiable instrument. You would have heard about negotiable instruments. Negotiable instrument means the instruments which are transferable from one person to another person, like promissory note, bills of exchange, checks. These are called as the negotiable instrument. We will discuss about negotiable instruments under the Negotiable Instrument Act, that is law with respect to the negotiable instruments. Six chapters or six laws and have a weightage of 60 marks in the examinations. There are two things which are important for the preparations of examinations. First things, you should understand the concept. Concepts are important to have a strong base at the CSEET level so that you can crack CS executive easily. That is the first thing. Second thing, as it is a MCQ based examinations, every word matters. Right? There are chances of asking questions based on the minute details as well. So you should study each and every word what is mentioned in the material. I have prepared the material and I'll share the material for you guys so that you can go to the material for solving the questions. Done? Got it? So these are the six chapters, and what is the weightage? 60 marks is the weightage of the subject. Done. So we will start with the elements of company. Which one? We'll start with the chapter number 2. Got it? Elements of law with respect to the company's laws. So before I start with the syllabus, let us understand few basic concepts of law. Basic concepts of what? Law. Are you guys ready? Make some noise, guys. Are you guys ready? Have energy, and wherever you guys get out, get it clarified then and there itself. And let's start. So we are discussing the law subject. Obviously, one should know uh, what is a law, right? So let us understand the basic concepts of law with the help of two questions. The first question which comes to everyone's mind is what is a law, right? What is the first question? What is a law? This is the first question for which you should have an answer before you start studying any law subject. Right? If I directly start with what is company, what is Companies Act or Negotiable Instrument Act, and if you don't even know what is law, doesn't make any sense, right? Let's show the basic knowledge of law. First question, what is a law? Second question, who makes the law? Who makes the law? This is the second question for which you should know the answer before you start studying any law. The third question, how the laws are made in India? Who makes the law? and how the laws are made in India. Got it? And the fourth question is why the law is made. Why the laws are made. What is the reason for making the law? And the fifth question is how the laws are made effective. How the laws are made effective. Made effective. These are the five questions for which everyone must know the answers before they start studying any of the laws. What is the first question? What is a law? Second one, who makes the law? Third one, how the laws are made. Fourth one, and fifth one, how the laws are made effective. And let us find the answers for every questions one by one. What is the first question? What is a law? What is a law? What do you mean by law? You would have heard this word many a times, right? According to you, what is a law? Oh, okay, she's saying rules and regulations. I will take these answers. According to you, law means, according to her, the law means what she's saying. It means first she said rules, correct, right? And she also mentioned one more word, regulations. Are they both same or different? What is the difference? Are they both law, first of all? She said what is law means rules and regulations. Correct. Law includes rules and regulations. Right, right. Yes or no? What else is considered as a law? Or is there any difference between rules and regulations? There should be some difference, right? Otherwise, why is they use these words, both rules as well as the regulations? If both are having the same meaning, they would have used only one word, right? If they're saying law means rules and regulation, there has to be some difference between the both, right? So the definition of law is given in the Article 13. Which article? Article 13 of Constitution of India. Have you heard about articles? So the contents of the Constitution of India are called as what? Articles. Called as what? We don't call them as sections, they are called them as what? Articles. Article 13, Clause 3 of the Constitution of India defines the word what? Law. According to Article 13, Clause 3, the law includes what includes? Law includes an act. Law includes what? It includes the act. Second one, it also includes rules. It also includes regulations. It also covers precedents. Precedents. It also covers the ordinances. Ordinances. And the one more is that it also includes the customs. Even the customs are also considered as law. Law means and includes what? Act, rules, regulations, precedents, ordinances, as well as the customs. What is the first one? Act. Now, what is an act? Act is a law. Is a what? When I ask some questions, you should answer. Everybody must answer. What is act? Act is also a law. But acts are made by passing a bill in parliament. It is made. Act is made by passing a bill. Passing a what? Bill in the parliament. A bill in the parliament. So now you should remember to make an act. What is required? Bill is required. What is required? And that bill is to be passed in parliament. That is both the houses of the parliament. Now, the one more question should pop up in your mind is what is the bill, sir? Bill is a draft legislation. What legislation? What is a draft? Which is not final. Draft agreement. They say, right, we are signing a draft agreement means what? Which is not final. So before a law secures the assent of both the houses, we call it as a bill. Call it as what? Bill. Bill is a draft legislation. What legislation? A draft which is not final yet. It becomes final only when it is approved by both the houses of the parliament. If it is a law concerning the corporate affairs, the Ministry of Corporate Affairs will introduce the bill. If it is a law concerning the financial matters, the Ministry of Finance will introduce the bill. If it is a law concerning the highways, the Ministry of Road Transportation will introduce the bill. We have the various ministers in the government, right? The concerned ministry will introduce the bill in both houses of the parliament, and once the bill is passed in both houses of the parliament, it becomes an act. Becomes what? And acts are made by passing a bill in what houses? Both the houses of the parliament. That is what called as the act. Clear? For example, we have the Companies Act. Which act? And Companies Act was made by passing a bill in how many houses? Both the houses. India is having a bicameral system of parliament. What is bicameral system of parliament? Two houses are there. How many houses? Two houses. So the act is made. What is made? By passing a bill in the parliament. Example is the Companies Act. Which act? Companies Act 2013 is the act. Right? In India, parliament meets only 3 times in a year. How many times in a year? And that is called as sessions. When the parliament meet to discuss and take decisions, it is called as what? Sessions. There are how many sessions? Three sessions. We call them as budget session, monsoon session, winter session. Have you heard about this? What is the first one? Budget session, where the finance minister presents the budget. Second one, winter monsoon session. And the third one, winter sessions. In these sessions, members discuss, they pass the bill, and they make various decisions in the parliament. So, parliament does not meet throughout the year, and they cannot legislate for each and every minute details. Is it possible to prepare a law which can cover each and every minute details? Or is it possible to make a law which deals with every changing scenarios? You think if you are a lawmaker, is it humanly possible? Even the lawmakers are also humans, right? Is it humanly possible to make a law which can cover each and every aspect or to cover each and every changing scenarios? For example, COVID-19 was an unexpected scenario for us where we were forced to do lockdown. Correct, right? And there was no laws to deal with such situations. And when there are no laws to deal with such changing scenarios, there must be some mechanism which act quickly. We cannot wait for the parliament to make a law. Right? For example, let's say war happened, or let's say there is some disease which is spreading like anything to the entire society. In that situation, if there is some laws to be made to deal with the changing scenarios, there has to be some mechanism to act quickly instead of going to the parliament. Because if you go to the parliament, it takes a lot of time. You should introduce the bill, it should pass in Lok Sabha, then it goes to Rajya Sabha. It may take months of time, 2 months, 3 months, 6 months, 1 year, 2 years. Getting it? That is why to deal with changing scenarios or for the proper implementation of the laws, we have something called as delegated legislations. What legislation? So, as per the Constitution of India, everybody listen. As per the what? Constitution of India. Have you heard about Constitution of India? Who drafted the Constitution of India? What is drafting? Preparations, which is not final. He drafted the Constitution of India. Who drafted the Constitution of India? Dr. B.R. Ambedkar. As per the Constitution of India, there are three organs of Constitution of India. How many organs are there? Three organs. What is the first one? Legislature. What is the first one? Legislature. What is the second one? Executive. Very good. What is the third one? Judiciary. What is the work of legislature? To make the laws. Very good. Who makes the laws? Legislatures makes the laws. Legislature what? Makes the laws. Makes the laws. makes the laws. They approaches the court, and court does the interpretation of provisions of the law. Somebody is saying it is not correct. Other person is saying it is correct. They approach whom? Court. And court does the interpretation of laws. So basically, as per the Constitution of India, who makes the law? Legislature makes the laws. Who makes the laws? Who execute it? Government execute it. Matlab executive enforce the laws. It is not possible for the legislatures to legislate throughout the year. And it is not possible for the legislatures to legislate for every minute details. And it is not possible for the legislatures to deal with every changing scenarios. That is why there is something called as delegated legislation. What legislation? Means Constitution of India authorizes the legislatures to delegate some of their powers to whom? Executive. Because executives are permanent, they deal throughout the year, right? So legislatures delegate some of the law making powers to whom? Executives. So when the legislatures delegate some of the law making powers to the executives, they call as delegated legislation. What legislation? Sir, where do the delegates, sir? How they delegate this, sir? For example, we have a Companies Act. Which act? In the Companies Act itself, if they want to delegate some of the power to executives, they mention the word called as prescribed. What is the word they use? It means they are authorizing the government to prescribe. Who is authorizing? Legislatures. Authorizing whom? To prescribe what is required according to the changing scenarios. Correct? And when the executive using this delegated power, what power? Make the laws, it is called as rules. Called as what? Rules. And rules are made by whom? Rules are made by whom? Executive. Executive nothing but what? Government. Rules are made by executive. Is it a delegated legislation? Is it a delegated legislation? Yes. Who delegate the powers? To whom they delegate the powers? And using these delegated powers, when the executives makes the law, it is called as what? Rules. And where the delegation happens in the act itself. What itself? Act itself. So here, in case of rules, for making the rules, there is no requirement of bill to be passed in both the houses. For making the rules, only what is sufficient? A notification in the official gazette. Notification in the what gazette? Official gazette. Now, what is official gazette, sir? Official gazette is nothing but official notification of the government. What notification? Official notification. If government want to communicate anything to the public officially, they mention it in what? Where do they mention it or where they publish it? What gazette? Official Gazette of India. For India, there is official Gazette of India. And for state, there is a state gazette. What gazette? Gazette is an, in Kannada, it is called as Rajapatra. Means, and any official announcements considered as official only if it is mentioned in that book. For example, they want to do appointment to the government or government officers. They publish the name of that person in the official gazette. You want to change your name. If you want to change your name, the change of name must be published in the official gazette. And once it is published in the official gazette, it is official, means it is deemed that everybody is aware about it. If government want to communicate something to the public, they communicate to the what? Official. It's like a newspaper. A newspaper of who? Government. Same like if college want to intimate something to the students, where do they mention it? Some book will be there, right? They maintain the record of notifications, right? All the circulars issued. In the same way, government also maintains the official publication that is called as the official gazette. They just mention it, saying that from these date, this is rule is applicable. That becomes a rule, becomes a law. Got it? Yes or no? So who makes the act? Who makes the act? Legislature makes the act. Who makes the rules? Which one requires the bill? Act requires the bill. Which one does not require the bill? Rules does not require the bill. Which one is easy to make? Which one is easy to make? Which one is difficult to make? Because that requires a bill to be passed in both. It's a time consuming process. But which one is superior? Obviously, what is superior? And we have the Companies Act. Which act? In the Companies Act, we have a concept called as illegal association. What association? So any association or a partnership firm having such number of partners or such a number of persons as prescribed. What is the word used here? As prescribed, we shall not exceed 100. Shall not exceed how much? Now, section number 464 of the Companies Act says an association or a partnership is called as illegal association if it is having such number of persons. What number of persons? Such number of persons as prescribed. Such number of persons as prescribed. What does it mean? The lawmakers are giving the power to whom? Power to whom? Executive. Saying that you prescribe the number according to the changing scenarios. According to the what? You say what association is considered as illegal associations according to the numbers. And that who will prescribe it? Because that power is given by whom? Legislatures. Law itself and in the act itself. And they're not giving unlimited powers to them. See, generally, whenever a delegation happens, if I am delegating my rights to you, I should delegate with some control. If I don't put some control, what you will do, you will abuse it, right? You may prescribe how much ever you want. That is why the lawmakers are saying you prescribe the number, but up to how many? 100. Maximum is how much? 100. If you want to go beyond 100, you should come back to us. Come back to us means whom? Legislature. Got it. So now, using this power, using this what? Power, what government has done, government has prescribed the maximum number of partners without registration is 50. How many? 50. If you go beyond 50 and if the partnership firm is not registered as a company, it is considered as illegal association. As on today, it is how much? 50. How much? Can government make it 60? Can government make it 60? Yes. The notification in the what? Official gazette. Can it make 70, 80, 100? 100 is 110. Why no? That is the maximum limit. So I am delegating the power to you with some control. I am saying you prescribe the number according to the changing circumstances. But up to how many? 100. Beyond 100, it should come back to us. Because we are the one who has the power to make the law in reality, just for the convenience purpose, just to meet the changing requirement, and just to bring a flexibility in the implementation of law, we are delegating some of the lawmaking powers to you. You means who here? Government. And when government makes the law, they are called as rules. Called as what? Rules. Acts are made by whom? Legislatures. Rules are made by whom? Executives. Executives makes the rules, and acts are made by the legislatures. Acts are made by whom? Legislatures. Are we clear with this? Yes or no? So act is different, rules are different. Then comes the regulations. What do you mean by regulations? Okay. Is there any difference between the rules and regulations, sir? Yes. Regulations are made by the regulatory bodies. What bodies? Can you guys give me an example of regulatory bodies in India? Very good. Who regulates the money markets in India? RBI regulates the money market in India. Who regulates the capital market in India? SEBI. These are the regulatory bodies which are established under the separate act of the parliament. Even ICSI is the ICSI regulates the profession of CS in India. ICAI regulates the profession of CA in India. When these regulatory bodies within the law under which they are being established makes the law, they are called as the regulations. Called as what? Who makes the regulations? Regulatory bodies makes the regulations. Are they law? Yes, they are also law. Are you bound to follow the RBI regulations? Are you bound to follow RBI regulations? Yes or no? Are you bound to follow SEBI regulations? Mandatory or not mandatory? So are you supposed to follow SEBI regulations, RBI regulations? Is it mandatory? Not mandatory. Mandatory. If you want to list your securities in the market, list your securities in the what? Market. Are you supposed to follow SEBI regulations? Mandatory or optional? It's also a law because they're authorized by the lawmakers to make the laws. But can they override the RBI Act? See, regulations are made by what bodies? And this regulatory body has the power to make law as per which act? RBI Act. Which act? And who has made RBI Act? Who made RBI Act? Legislature. Every acts are made by the legislature because they are the one who has the power to make the laws. And when RBI makes the law, it should be in conformity with which act? RBI Act. Are you guys getting it? Resa, no. Who makes the regulations? Regulatory bodies. And we have IRDCs, that Insurance Regulatory and Development Corporations. They make the law with respect to insurance. Getting it? ICA regulate the profession of CA, and they also make some regulations for governing the profession of CA. So even regulations are also considered as what? Law. Got it? Law includes what? Act, rules, regulations, and next one is precedents. Now, what are precedents? Are precedents are nothing but judgments of the court. What of the court? Judgments of the court. It is also called as judge-made law. What law? Judge-made laws. Judge-made laws are considered as the precedents. So now, if Supreme Court says Triple Talaq is unconstitutional, where the husband could give a divorce to a wife in the Muslim community, the husband could pronounce a talaq to the wife without any reasons. And Supreme Court say that is unconstitutional. Will it become a rule of law to be followed by the lower court? If Supreme Court say triple talaq is unconstitutional, when High Court say it is constitutional, why no? Are they bound to follow it? Are they bound to follow it? Because it is a judgment of the which court? Superior court. So that abolition of triple talaq by the Supreme Court becomes a what of law now? Rule of law. It has to be followed in similar cases. What cases? So even precedents are also considered as law. Precedents are nothing but judgment of the court, which becomes a rule of law to be followed in the similar cases. If again, for example, let's say a Muslim woman filed a case against her husband saying that triple talaq is unconstitutional, triple talaq should not be valid. Supreme Court said it is not valid. If similar case comes to the court, let's say one more Muslim woman filed a case against her husband in the High Court, challenging the talaq given by the husband. Is High Court supposed to follow the same judgment of the Supreme Court? Yes. That is how you can bring uniformity in decisions. Otherwise, there will be chaos, right? If Supreme Court says something, High Court says something, says other thing. There can't be any order in the society. That is why we have something called as precedents. Called as what? Precedents. And the judgments of the court, even that is also considered as a part of law. Now what? Who makes the precedents? Judges. Decisions of the courts are considered as the precedents. Is it also considered as law? So what is the first one? Act. Second one, rules. Third one, fourth one, precedents. Then there is something called as ordinances. You would have heard about ordinances. Have you heard about ordinances? Who is the head of the executive of the center? President is the head of the executives. And who is the head of the state executive powers? Governor. Have you heard about president and governor? Yes or no? President. Have you heard about president? President is the he's the head of the executive. Head of the what? Executive. So all the actions of the central government will be in the name of president. All the actions of the state will be in the name of governor. In the name of what? Governor. Are you guys getting it? Yes or no? So what happens when the parliament is not in session? It is not in session. And if the government thinks they want to bring a new law, what law? New law, a urgent law to be made to deal with the changing circumstances, and the parliament is not in session, there is some route called as the ordinances, where the president can promulgate an ordinances and that becomes a law to be followed by the people of India. In the same way, if state government want to make a law, see, state government cannot make laws. Agree with this? Only who can make law? Legislature. When I say legislature, it means that houses. There should be both houses. We have Vidhana Saudha and Vidhana Parishad, legislative assembly, and legislative council. Resa no. And in parliament we have what? Lok Sabha and Rajya Sabha. It has to pass in both the houses. Now government, central government wants to bring a new law. If there is an existing law and if they want to make a rule, they can make the rules because they have the power to make the rules, not the law. If there is a new law to be made, only who can make the new law? Legislature. But legislature is not in session. In that situation, they can use the concept called as what? Ordinance. They can request the president to make a law, and that law will be valid till the time the parliament comes into session. Yes or no? So who makes the ordinance? President or governor? President or what? Are you guys getting it? For the state matters, governor makes the law. And for central matters, president promulgate the ordinances. Our ordinances are considered as laws. Are they laws? Are we bound to follow the ordinances? Yes. So ordinances are made by the president or governor. President or the governor. Are you guys clear with this? And when the question of ordinances will arise? When the parliament is not in session and government wants to make some laws. Clear with this? Next one, we have something called as customs. What is customs or what are customs? Practices. What are customs? Practices. Now tell me how the marriage happens if you are a Hindu, how the marriage happens. Huh? Am I asking some strange question, alien questions? You guys are giving a expression as if I'm asking some science question. Explain mathematics. I'm asking a simple question. How the marriage happens? How do we know, sir? Huh? But I observe the marriages, right? How the marriage happens? Don't give me a typical definite, typical what is a sophisticated answer. Just give me a layman answer. How the marriage happens? ಹೆಂಗಮ್ಮ marriage ಆಗತ್ತೆ? How marriage happens? She's saying, ಹಿಂಗಂದ್ರೆ ಹೆಂಗೆ? Tali. That's what you tie Mangal Sutram and you perform 7 steps, right? 7 steps. Oh, you guys don't even know what is how the marriage happens. Very good. Who believes in nowadays? Nobody believes in marriage, sir. We are Gen Zs. We don't believe in marriage. Of course. Who said of course, sir? That is how the see your marriage is valid only when it happens as per the customs. And different communities have different customs. If you go to North India, they have a different custom. They don't do this tying up tali and all. They just put this sindoor. So once the boy apply the sindoor, that means he has expect the wife. And in South India, we have this tradition of performing the 7 steps. It is not only tying of tali. You could also perform the 7 steps. Only when the 7 steps are complete, it means that marriage is solemnized. Otherwise, that marriage is not valid. If boy and a girl elopes and they get married in front of some temple, by just tying tali, it is not a valid marriage. You have to perform all the rituals, or you should get the marriage registered. Either you should get the marriage done, either as per the what customs, or as per the law. Like you should get the marriage registered. If you don't perform the customs, the marriage is not valid. Got it? So our customs are considered as the law. Our customs are considered as the law. Yes, there are few customs which have the legal force of law. If you want to get married, you should get married as per the law. Correct, Janya? Okay, I should also concentrate on the online students. Sorry, guys, you guys can ask questions. Everyone, online students can also ask questions. Yeah, I hope you guys are clear with this. Everybody, customs are also considered as what? Laws. For example, our personal matters. Personal matters in the sense marriage, and divorce. These divorce, we have a separate law now. Codified law is there for Hindu law, and for Muslim law there is no codified law. That is why there is a demand for the uniform civil code in the society for all the religions. So marriage is happens in a different way for the Muslims, marriage happens in a different way for the Christians, and marriage happens in a different way for the Hindus because we have a different customs. And even customs are also considered as a what? Law. And all these customs should be a legal customs. What customs? Valid customs. Right, right. In case of Muslims, the marriage happens in the presence of two witness. How many witness? Two witness. Where it's kind of civil contract where the boy makes an offer to the girl. It's called as ijab, and the girl accepts it by saying kabul, by saying three times kabul, 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 and she accepts it in the presence of two witnesses, and there will be the one who solemnizes. He enters it in the books maintained by him. So that's the custom. So even customs are considered as what? Law. Got it? These are this is the definition of law as per the Constitution of India. So what is law? Law includes act, rules, regulations, precedents, ordinances, customs. Are all the same or different? Who makes the act? Who makes the rules? Who makes the regulations? Who makes the precedents? Judges. And who makes the ordinances? President or governors. And who makes the customs? Customs are nothing but practices which are practiced over a period of time by the society. Which one is superior out of all these things? Act. Act is superior. Can rules override the act? Rules are made within the framework of what? Act. Got it? I hope you guys got an answer for the first question. What is law? What is and what is an act? Act is a law which is made by passing a bill in the parliament. And who makes the law in India? Legislatures. They are the supreme lawmaking body, but they can delegate their power to the other authorities as well. That is executive and the regulatory bodies. Got it? So we got the answer for the first question. What is the first question? What is the law? Second question. Tell me who makes the laws in India. Legislature are the one who makes the laws in India. So we got the answer for the second question as well. Who are legislatures? The elected representative of the people are considered as what? Legislatures. And collectively they're called as houses. Lok Sabha and Rajya Sabha. Are we clear with this? Now, how the laws are made in India means how the act is made. We know how the rules are made. Rules are made by notification in the what gazette? Official gazette. Even regulations are also made by notification in the official gazette. Now, for making an act, there is a procedure. Making a what? Act. So, who makes the act? Legislatures. So, the law making process. What making process? Law making process. The law making process starts with the introduction of bill. Introduction of what? Bill. Concerned ministry introduces the bill. Introduces the what? Bill. Where it is introduced? The bill is introduced in the Lok Sabha. Which house? Lok Sabha. In Lok Sabha, there will be members of members of what? Representative of the people. It's a house of people. It is also called as lower house. What house? In the Lok Sabha, what happens? There will be a discussions among the members in the Lok Sabha. After discussions, the bill is presented for arguments. Between what? Arguments. And there will be arguments between the ruling party members as well as the opposition party members. First, discussions will happen, then arguments will happen, then the Speaker of the House present the House for voting. Voting by whom? Members. And once the vote secures the required majority of the vote in its favor, the bill is passed. The concerned ministry present that bill before the members, and speaker approves it. Once the bill is presented in the house, there will be a discussions among the all members. There will be ruling party members as well as the opposition party members. Then there will be arguments. Then the bill goes for voting. Once the bill secures the required majority of votes in its favor, it becomes an act. Becomes what? Act. Becomes what? Act. Are we clear with this? So introduction of bill happens in what? First, Lok Sabha. Once the bill is passed in Lok Sabha, it goes to where? Rajya Sabha. Is it a upper house or lower house? Upper house. Again, the three things will happen in these three houses. Again, what will happen in this Lok Sabha? There will be discussion. There will be what? Discussion. Again, there will be arguments between the ruling party members as well as the opposition party member. Then the president of the house present the bill voting, and if it secures a majority of the vote, then the bill is passed. Once the bill is passed in Rajya Sabha, it goes to whom? It goes to the president. Goes to whom? President. If it is a central law, it goes to the president, and if it is a state law, it goes to the governor. So president should give an assent to the bill. Assent to the what? Bill. Now, what do you mean by assent? Accepting the bill. So once he gives the assent, it becomes an act. Till that time, it is called as what? Bill. Everybody, it is called as what? Bill. Till it is passed in both the houses, it is called as bill. And once it is passed in both the houses, it is called as what? Act. This is how the laws are made. In the final, sir? No. This act should be notified. Should be what? Notified. It should be notified in the official gazette. In the what gazette? Official gazette. Official gazette of India. Once it is notified in the official gazette of India, then it becomes applicable to the people of India. Unless until it is notified in the official gazette, it is not applicable to the people of India. Only if it is notified, it is applicable to the people of India. People of what? India. This is how the laws are made in India. What is the first step? Bill is prepared and introduced in the Lok Sabha. What happens in Lok Sabha? Discussions, argument, and pass. And it goes to where? And everyone must answer. If I see anyone not answering, I'll ask questions. And it goes to where? Rajya Sabha. What happens in Rajya Sabha? Discussions, arguments, and pass. Then it goes to whom? For his assent. Once the president gives the assent, it becomes an. This is how the laws are made in India. So we got the question answer for the three questions. What is the first question? What is law? Second question. Third question. How the laws are made in India. Got it? What is the fourth question? Why the laws are made? You guys tell me why the laws are made. What happens if there are no laws? There will not be any order. What is order? Systematic functioning of things, correct, right? So can we say for maintaining the social order, what order? What is required? Laws are required. Without law, can you imagine a society? Where there is society, there must be a law. And where there is law, there is only what? Society. They are the faces of two faces of the same coin. You cannot make a law for the animals. You can only make a law for the society. Correct, right? Yes or no? So why the laws are made? To maintain the what order? Social order. What order? Are you guys clear with this? First one is what is law? Second one, who makes the law? Third one, how the laws are made. Fourth one, why the laws are made. Why the laws are made? To maintain the social order. What order? And the last one, how the laws are made effective. Means how people are made to follow the laws. If government requests saying that people please follow the laws, will they follow the laws? Then how can we make people follow the laws? You think from a legislature point of view. See, As I said, there is no need to hesitate in my class. Everybody has the right to answer in my class. And even if you're wrong, it doesn't matter. It takes a lot of courage to ask questions and give answers in the class. I don't expect right answers from you guys. I expect answers from you guys. Getting it? Max, expect questions from you guys. More the questions, more the clarity. Remember it. And you're here for learning something new. Got it? So you guys tell me uh, what I was discussing. How the laws are made effective. The last question, fifth question, right? How the laws are made effective. Laws are made effective. How they are made effective? Okay, very good, very good. We can impose what? Fine or penalty. Now she used two words again. I like these answers. She said rules and regulations, and now we got to know what is the meaning of the word rule as well as the regulations. Now she is saying we can impose fine or the penalty. Is it or and? Anything like fine and penalty. There is one more thing called as imprisonment. Have you heard about imprisonment? That means he's sent to the jail. He used two words here, fine and penalty. Are they both same or different? What is the difference? Okay. Penalty. What is the difference between fine and penalty? Both are required to be paid to the government. The difference lies in how the payment is to be done. Fine can be levied by the government only after adjudication. Sir, what is this, sir? You're using too many law jargon, sir. Too much of English, sir. That is how it works. You get to learn many new law words and law terms because you're studying what law. We'll explain each and every word. Okay, don't worry. So fine and penalty is different in the way they are collected. Both are punishment, but there is a difference in how they are collected and why they are collected. Major difference is fine is collected for non-contravention of law. What of law? Contravention. If you violate any law as a punishment, the collect fine. And penalty is levied as a punishment for non-compliance of certain deadlines or certain provisions. For example, if you don't file income tax returns on time, there is a penalty. But if you violate the laws, violate the what? Laws. For example, let's say you have done something wrong. There will be what? Fine. There will be what? Fine. These are serious offenses. If there is a serious violation of the law, there will be what? Fine. If it's just a procedural non-compliances, ನೀವು ಇವತ್ತು ಫೈಲ್ ಮಾಡಬೇಕಿತ್ತು ಇವತ್ತು ಮಾಡಿಲ್ಲ ಪೆನಾಲ್ಟಿ ಪೇಮೆಂಟ್ ಮಾಡಿ. ನೀವು ಕಾಲೇಜಲ್ಲಿ ಮಿಸ್ಬಿಹೇವ್ ಮಾಡಿದ್ದೀರಾ, ಫೈನ್. Remember in college, if you don't pay the examination fees on time, they collect fine or penalty. Penalty with penalty. That is not called as fine. That is called as what? Penalty. And if you violate college rules and regulation, they collect what? Fine. And most of the fines are collected after adjudication. After what? Now, what is adjudication, sir? Levy means to collect. Adjudication means, listen everybody, adjudication, levy means what? To collect. Adjudication means judicial determination. What determination? Of a dispute is called as adjudication. When the court decides the matter, it is called as what? Adjudication. So what requires adjudication? Collection of fine. If government want to collect the fine, they should file a case against you. Who should file a case? Who should file a case? Government. Against the whom? Accused. And government imposes the fine. Correct. Violations. Violation means you're not complying with it. So for collection of penalty, there is no requirement of adjudication. There is no need to go to the court. For example, if you don't file income tax returns on time, you can file it with penalty. Paid with what? Penalty. But for collection of fine, the government should file a case against you and the court will fix what is the amount of fine. Now you can ask me a question, sir. In case of traffic rules violation, we pay fine, sir, and we don't go to the court for payment of fine. Correct, right? But in reality, you have an option to go and pay it in the court. And there are few offences which are non-compoundable. Means you cannot compromise them and you cannot pay the fine to the police officer. You should go to the court only. For example, drink and drive case. If it is drink and drive case, the fine is paid in the what? Court, not to the police officer. So fine requires adjudication. Collection of fine requires what? Adjudication. Whereas penalty, there is no adjudication. What is not required? No adjudication is required. There is no adjudication. For levy of fine, adjudication is required. For levy of penalty, no adjudication is required. What is adjudication? Judicial determination of dispute. Judicial determination. What determination? Judicial means what? Court. When the court decides the dispute, it is called as what? Judicial determination of dispute. That is required in case of penalty. Sorry, fine. Penalty, what is not required? Adjudication is not required. If you don't file the forms on time as per the Companies Act, you are supposed to pay the penalty, not the fine. And there are fine provisions also. Levy of fine, what is required? Adjudication is required. And what are the serious violations? Penalty or fine? Fine. Are more serious in nature. Got it, everybody? And what is imprisonment? Where the person will be put behind the bars for a violation of law. Especially criminal cases, the person is sent behind the bars. These are the ways in which the laws are made effective. What is the first way? By imposing fine. Second one, penalty. Third one, and in case of civil cases, there is one more way by asking him to pay the damages. Have you heard about damages? What is damages? Compensation. Court may ask you to pay the compensation to the person who has suffered a loss because of your breach of promise. In case of civil contract, if there is a breach of contract, you are asked to pay the compensation. Got it? So the laws are made effective. What is made effective? Laws are made effective either by imposing fine, penalty, damages, or imprisonment. Got it? And you got the answer for how many questions? What are the five questions? What is the first question? What is the law? Second one, who makes the law? Third one, how it is made. Fourth one, why it is made. Sixth one, how the laws are made effective. How they are made effective? By imposing fine, penalty, damages, or imprisonment. They're all basic knowledge which everyone must know before they start studying any law subject. Because you'll come across with a word called as rules and act. And if you don't know what is the difference between act and rules, you'll just simply remembering something but not learning anything. Now you got the difference between what is act, what is rules, what are regulations, what are customs, what are precedents, what are ordinances. Yes or no? With these, we are done with the basic concepts. Done. So there are a few more concepts. There are two more concepts which I want everyone to know. First one is in case of law, we read or we have section numbers. What numbers? We give number to the provisions of the law. We call them as section numbers. What numbers? And the numbers are given for the easy identification and how to read the section numbers. To read section numbers, for example, say, let's say it is like section number 4, section 4, subsection 3, clause 1, subclause 8. Have we read it? What is the first number? This is called as what? Section. First number is called as section. Second number is called as what? Subsection. These Roman numbers are called as what? Clause. And the alphabets are called as what? Subclause. Same like how you write the point, subpoint, like that. First number is called as what? Section. Second number is called as what? Third one, clause. And the fourth one, subclause. Clear with this, everybody? Yes or no? Now, I'll give one more example. You guys should read and tell me what is the how you guys gonna read this one. For example, let's say 5, 4, 2, yeah. How you read this? Very good. Subclause A. Done. Got it. Now, in case of civil cases, what cases? Law. In case of law, we can classify the cases into two types. Civil cases. Have you heard about civil cases? Have you heard these words like cases, civil case, criminal code, civil code? You would have heard all these things, right? Cases can be classified into two categories. What are the two categories, sir? First one, it can be civil cases. What cases? Where the individual rights are involved. Then there can be a criminal cases. What cases? Criminal cases. Where there is a interest, public interest is involved. Criminal cases, civil cases. What cases? Civil cases. Second one, criminal cases. In case of civil cases, individual rights are involved. What is involved? It is a right or a wrong against an individual person. But in case of criminal cases, it is a wrong against the society. It is a wrong against the what? Society. If you do crimes, you are a wrongdoer against the what? Society. You are considered as a public enemy. If you are a thief, you are a public enemy, not an individual enemy. You are what enemy? Public enemy. If you do murder, public enemy. If you have a contract and if you break the contract, civil wrong. What wrong? Civil wrong. Only the wrong is done against an individual person. In case of civil cases, we call them as to what? Suit. Civil cases are filed by initiating something called as what? Suit. Called as what? Suit. And suit is instituted by presenting a plaint. Presenting a what? Plaint. If you want a remedy from the court for violation of individual right, you go to the court, you file a plaint. You file a what? Plaint. Not complaint. It's a what? Plaint. You present a plaint in the civil court against the other person to seek the remedy from the court. And that proceedings are called as what? Suit. Civil suit. What suit? And there will be two parties in a civil suit. What are the two parties? First one is plaintiff. Who is the first one? Plaintiff. Second one is what? Defendant. Second one is defendant. Who is the plaintiff? Very good. The person who filed the case. Person filing a suit is called as what? The person who files the suit is called as the plaintiff, and the person against whom the suit is filed is called as what? Defendant. Against whom the suit is filed. Against whom the suit is filed is called as defendant. Are you guys clear with this? You tell me, civil cases are initiated by filing a what? Suit. By presenting what? Plaint. And there will be how many parties in a civil suit? Two parties. What are the two parties? Plaintiff and defendant. Who is plaintiff? The person who files the case is called as plaintiff. Who is the defendant? Person against whom the suit is filed is called as the defendant. Got it? This is in case of what cases? Civil cases. Is it a violation of right of the many or right of an individual person? Individual persons. Got it? When comes the wrong against the society? Crimes. In case of crimes, the cases are initiated by filing a complaint. Filing a what? Complaint. You file a complaint in the court. You go to the police station, you give the information to the police officer, they register an FIR, first information report, then they do investigation, when they report, give a report to the court. Nothing but they file a complaint in court. In case of criminal cases, it is not you file a complaint. You're not the one who prosecute the other person. The state is the one who prosecutes it. If there is a crime, if there is a what? Who prosecutes the criminal? State. So it will be state versus accused. It is always what? State versus accused. Have you heard about accused number one, accused number two, accused number three, A1, A2, A3? And who is the one who filed the complaint? State. So if somebody steals or somebody murders, let's say a murder happened, who prosecutes the accused? State. That is why it is always state versus accused. You would have heard about you would have seen the movie names, right? State versus somebody. There is a movies also. Criminal cases, who prosecutes the criminals? State, state government. Got it? Understood? This is in the lower court. You cannot. Plaint is for civil cases. Both are to initiate the proceedings. But to initiate the criminal proceedings, you file complaint. To initiate the civil proceedings, you file a plaint. In a plaint, you make a prayer to the court. Sir, I had a contract with this person. He broke the contract. I want these remedies from the court. It is called plaint. Getting it? Complaint, you want somebody to be punished because he has done something wrong or violation of criminal law. Got it? So, criminal cases, there will be two parties, complainant and the accused. Civil cases, there will be how many parties? Two parties. What are the two parties? State and criminal cases, state and accused. Civil cases, plaintiff and defendant. One who is called as plaintiff? Person who files the case. Who is called as defendant? Online students against whom the case is filed. This is called as original suit. What suit? When the case is filed, it is called as original suit. OS. You would have seen this board, right? If there is a disputed property, they display this board saying that this property is under dispute in this code under OS number this O dot S number dot OS means what? Original suit. Oh my God, yeah. Everything makes sense once you start understanding it. Got it? Now, what if plaintiff won the case? Can defendant go for an appeal? Can he go to an higher court? Then the name of the parties will change. In case of appeal cases, in case of what? Appeal, the name of the parties will change. In that situation, the one who goes for an appeal is called as appellant. Called as what? Appellant. And the person against whom the appeal is preferred is called as what? Respondent. Respondent. In most of the high court cases, what cases? In YouTube, they telecast the high court proceedings live telecast ಮಾಡ್ತಾರೆ. 10 cases na uh, high court cases na in high court. There you would have seen judges pronouncing saying are calling them as like respondent number one, respondent number two, appellant number one, appellant number two, because it is an appeal. It has been preferred in the high court. So in appeal cases, we don't call them as plaintiff and defendant. We call them as what? Appellant and respondent. Same thing remains even in case for criminal cases. Got it? This is how you're supposed to read the case name. I hope you guys got an idea of who is called as plaintiff, who is called as criminal, who is called as uh, defendant, appellant as well as the respondent. And this is the basic, pretty much basic knowledge which is required. Okay, I'll discuss one more thing, last concept of basic thing. Then we will start with your syllabus. Then we can classify the laws into how many laws? We can classify them into different categories. We have so many laws. How many laws? So many laws. But and everybody is presumed to be aware about those laws. There are around so many laws, even which I am not aware about it. But what law presumes? You're aware about it. Even if you're not aware about it, you're aware about it. And if you commit any wrong, are you punishable? Not punishable. Is growing ganja punishable? Not punishable. You know it. What if you don't know about it? And you grow ganja and can you claim the innocence saying that I was not aware about it? Because ignorance of law is no excuse. You are presumed to be aware about it. What if I'm illiterate? I'm a village person. I come to Bangalore. I don't follow traffic rules. I cause accidents. Am I punishable? Not punishable. Arre, how am I punishable? I'm not aware about the laws, right? Who assumes it? Law assumes it. Once it is notified in the official gazette, each and every citizen of India, not only citizen of India, every person who is in India are presumed to be aware about laws of India, and you are bound by it. Even if you're a citizen of USA, you come to India. The moment you come to India, you should follow the Indian laws. In the same way, if you're a citizen of India, you go to USA. The moment you place your legs on the land of USA, you're supposed to follow the laws of USA. That is how the judicial system works, our legal system works. Got it, everybody? Yes or no? So we can classify the laws into three types. First one is personal laws. What is the first one? Personal laws. Second one is civil law. Third one is criminal law. Criminal law. What are personal laws? Are the laws which deals with personal matters like marriage, divorce, marriage and what? Divorce. These are considered as what laws? Personal laws. Matrimonial matters are considered as personal laws. What are civil laws? Where individual rights are involved. What are criminal laws? Wrong against the society. Civil laws can be again classified into one more time called as the business laws. What laws? Business laws are also civil laws. Now, what do you mean by business laws, sir? The laws which are applicable to the business. Everybody, that is a subject name, right? What is the subject name? Business law. What law? And what is business law? Law applicable to business is called as what law? And what do you mean by law? It can be act, there can be rules, there can be regulation. If you are doing a business, you are supposed to comply with. If you are a company, you should follow companies act, should follow company rules, and if you receive any money from abroad, you should also follow with RBI regulations. And if you list your securities in the market, you should follow what regulations? SEBI regulations. So business are nothing but laws which are applicable for what? Business. And how can you do a business? You can do business either individually or through partnership or in the form of company or in the form of HU. That is left to you choose whatever you want. For every business, there is a laws applicable to you. If you do partnership form of business, different rules. Company form of business, different rules. Nothing but different laws. Getting it? Getting it? And we're gonna study which laws? Business laws. And what are business laws? Laws applicable for the business. Are we going to study about personal laws? No, we're not going to study about marriage, how the what is which marriage is lawful or divorce. We're not going to study all those things. Study only what about what laws? Civil law. But to what law? Business law. Are you going to study criminal laws? No. You're not going to study what is theft, murder. No, you'll not. You study some part of criminal law in CS executive level. In CS executive, we have subject called as jurisprudence, interpretation, and general laws. There you study about some part of, not entire criminal law, some part of it which are connected with business. For example, theft can happen in business also. You study about theft. Or there can be a breach of trust, criminal breach of trust. ಅಂದ್ರೆ ಏನು? For example, shareholders, our company has entrusted some documents to you, or funds to you, believing upon your credibility or trusting you. And if you misuse it, it's a crime. You study about that because it is connected with the business. You'll not study all the criminal laws. You'll not study about murder. You'll not study about uh, uh, other kinds of crime. You only study about whatever is connected with the business, because you're a commerce student, not a law student. Uh, Sir, you can even tell that I was growing castor leaves by mistake. I grew ganja. Okay, if you're Shrestha, Shrestha Bansal, Shrestha Bansal. Uh, is he offline student, online student? Sista. Huh? E. Oh, is it E? Okay, I was confused. He's absent today, is it? He's attending online. He used to attend offline, but today he's attending online. Okay. Maybe he's harvesting the ganja leaves, I guess. He'll be present tomorrow. Bansal, you can say whatever you want, say Bansal, but at the end of the day, truth prevails, and the police officers know how to find the evidence, whether it was intentional, whether it is accidental. That is why we have the, what is it, advocates, right? Right? So if you, sir, you can, judge some samples too. Yeah, yeah. It's not that simple. Anyways, samples, it seems. It's a non-bailable offense, sir. It's a serious offense. Yeah. Uh, are you guys clear with the basic concepts of law? Everybody got it? Done? So with these, we are done with the basic concepts. Now we should start with the syllabus. Start with what? Syllabus. Are you guys ready? Make some noise, guys. Are you guys ready? As I said, law is the one subject which should be part and parcel of your life from now onwards. Why? Because you're going to be the expert in corporate laws. What laws? If somebody is doing business, let's say break, I will give at 10:30. Breakfast break is I will give us 10 o'clock. Okay. If anybody want to use the washroom, for that there is no need to ask. You can go out and use the washroom and come back. You should come back within 3 or 4 minutes. That's it. Okay. Break. I will give the breakfast break 10, 10:30 or 10. You guys have the options. 10:30 to 11 is the breakfast break. Then your class will, I'll give one more break in between, uh, 11 to 1:30. I will give one more break of 5 minutes. That's it. And class will end at 1:30. Fixed. We start at 8 o'clock and end at 1:30. And everyone should be in class by 8 o'clock, and you can leave the class by 1:30. Today is the first class. I'm giving the excuses, but try to come to the class on time. Because you miss a few topics in the starting, then it becomes difficult for you guys to catch the class. And if you miss one class, then things becomes more difficult for you guys. Getting it? If you really want to do something, or if you really want to become company secretary, more than becoming company secretary, if you're serious about your examination and your career, you should be regular to the class. Getting it? By for any extraordinary reasons, like beyond your control reasons, if you miss the class, one thing you should do is either attend online or watch the recording and come to the next class. You should be serious about the studies. That is the one thing which I'll never compromise. Getting it? Yes or no? Let's start with the syllabus. Start with the what? Syllabus. Let's go. Let's start. Shall we start? Let's start with the Companies Act. Elements of company law, the bread and butter of the company secretaries. Elements of company law. Chapter number 2. Chapter number what? 2. Let's concentrate. I'll make you guys remember the provisions. Try to understand the concept. If you understand the concept, you'll remember it. Okay? Listen. First, let us understand. Concepts about company law in a vague, like when we'll go word by word or provision by provisions, topic by topic. First, let us understand what's this company, how, why this works, why are we studying about the company sector and all this thing. See, in the Companies Act, we're discussing about elements of which law? Company law. Company law covers the law called as Companies Act. Which act? Companies Act 2013. It also contains the company's rules. Company's rules. So most of the rules are made in 2014. Both are considered as laws. We have an act as well as the rule. In the Companies Act, there are 470 sections. How many sections? 470 sections. In that you have subsection clauses, subclauses. And you study all these 470 sections step by step. In executive study few section numbers, and in final you study few section numbers. Sir, like sir, who will study 470 sections, sir? It's too hectic, sir. Ma'am, it is like doing operation. If you don't know all the procedures of operation, and if you know only few steps of operation and you go for operation theater, the patient will die, right? In the same way, if I'm an engineer, I want to do some business. If I come to you asking for some advice, can you say, I only know this part of the companies, I cannot advise you on the other part? No. And what sounds difficult now or what sounds complicated now for you guys sounds silly once you complete your CS. When I was in your level, CSEET level, I used to feel like 470 sections. Oh my God. And once you become CS, by the time you become CS, you'll go through all the section numbers, right? So that time it feel like only 470 sections. You study some other laws as well, not only this section. What was complicated once sounds silly once you complete it. You have to persist with that subject, and we should have the what is it courage to break it. Getting it? Yes or no? So it's you're gonna learn all these section numbers because that is what going to get you some money in the future when you go to the corporate. There are how many sections? 470 sections. And these 470 sections are grouped under the chapters. The what? Chapters. We have given the name for each chapters. There are 470 sections, right? According to the topics with which they are dealing with, we have classified them into chapter. Chapter 1, these section numbers. Chapter 2, these section numbers. Chapter 3, these section numbers. So like this, we have how many chapters in total? 29 chapters. Along with this, we have something called as schedules. Have you heard about schedules? Provide detailed information about some topics, we use the concept of schedules. Because if I start describing everything in the act itself, it becomes lengthy. So we use the concept of schedules to provide a detailed information about a subject matter. What do we use? Schedules. And there are how many schedules? Seven schedules. For example, Schedule 2 of the Companies Act provides the useful life of an asset. We calculate depreciation. Companies Act itself provides the what life? Useful life. Or how to calculate the useful life of an asset. So for the preparation of financial statement, Schedule 3 provides the format of financial statements. Schedule 3, prepare the balance sheet as well as P&L account. As per which schedule? Schedule 3. And the format of MOA and AOA is given under the Schedule 1 of the Companies Act. So like this, when lawmakers want to give some detailed information about a subject matter, they use the concept of schedules. Got it? There are how many schedules in total? How many sections? How many chapters? How many schedules? Seven schedules. Got it? Clear? Along with this, we also have the company's rules. What rules? Company's rules. Got it? Now, for the proper implementation of the Companies Act, what implementation of Companies Act? We have a separate ministry in the government. So, Companies Act are the companies come under the separate ministry called as the Ministry of Corporate Affairs. Which ministry? Ministry of Corporate Affairs is the ministry which oversees the implementation of Companies Act. Under the MCA, we have the regional directors. What directors? These IAS officers. The regional directors who report to whom? Report to whom? MCA. There are various regional directors, North region, South region, Northeast regions. Karke we have the regional directors. Under the regional directors, we have the ROC. What is ROC, sir? Register of Companies. Register of Companies. ROC. At the top, we have MCA. Under MCA, we have regional directors. Under RD, we have the ROCs. Every state has one ROC. Every state has how many ROC? One ROC. State of Karnataka, ROC is there. State of Tamil Nadu, ROC is there. State of Maharashtra, ROC is there. State of Gujarat, ROC is there. If you want to register your company with ROC, Register of Company. If you are starting a company in Karnataka, ROC of Karnataka will have jurisdiction. What is the word? Jurisdiction. What is jurisdiction? Power. Coverage. If murder happens in SS Academy, which police station has jurisdiction? Jayanagar. Can you go and file a complaint in Basangudi police station? No. Getting it. In the same way, if you start a company in Karnataka, which ROC has jurisdiction? Karnataka ROC. If it happens in Gujarat, Gujarat ROC. So every state has one ROC. Correct? But there are two states where we have two ROC. Every state has how many ROC? But there are two states where we have two ROC, one in Tamil Nadu, one in Maharashtra. These two states have two ROCs. In these two states, Tamil Nadu, we have two ROC. What are the two ROCs, sir? One in Coimbatore, and next one is Chennai. In Maharashtra, we have two ROC. What are the two ROC? One in Mumbai, other one is Pune, Mumbai and Pune. Other than these two states, every state has how many ROC? One ROC. ROC report to whom? RD report to whom? MCA. MCA is answerable to Parliament because Parliament is nothing but people. Got it? Yes or no? So who administers the Companies Act? MCA. Under MCA, what do we have? Under RG, what do we have? ROC. What do we have? ROC. What is ROC? Register of Companies. Got it? Now, if there is any dispute between the people, not people, if there is a dispute arising out of the Companies Act, to deal with the Companies Act dispute, there is a separate forum. What is it? Separate forum or separate institutions are there to deal with the company matters. What matter? Company matters. We call them as tribunals or tribunals. See, we have civil court, we have a criminal court, high court, supreme court. Correct, right? But civil courts are already burdened with so many cases. There are so many cases pending in civil court. And civil judges doesn't have that expertise to deal with company matters. They are expert in property laws. Are you guys getting it? So there is no required expertise to dissolve the company's act matters in a quick manner. The level of knowledge of CS when it comes to company law is different from the level of knowledge of an advocate about companies act. They are expert in civil laws. They are expert in how to present the case before a judge, but they're not expert in companies act. They study the companies act as a subject. One paper, one subject. They study the paper, they write the exam, they forget it because for them the bread and butter is what? Unless they want to practice corporate law. They don't take corporate law serious. They take what? Civil law serious, like property disputes, transfer of property act, matrimonial cases, divorce cases. That is their expertise. Corporate law is a CS expertise. Getting it? Yes or no? So to deal with this company matters dispute, there is a separate forum established by the government called as the tribunals or tribunals. So we have the two tribunals all over India. One is NCLT. What is the first one? NCLT. If you're not happy with the decisions of the NCLT, you can approach NCLAT. NCLAT. If you're not happy with the NCLAT, then you can approach whom? Supreme Court. Supreme Court is the court of last appeal. In this case, there is no involvement of the High Court. Earlier, there was an involvement of High Court, but now there is no involvement of High Court. Are you guys clear with this? If you have a dispute, where do you file a case first? If you're not happy with NCLT, if you're not happy with NCLAT, and Supreme Court is the court of last appeal. Now, what is NCLT, sir? National Company Law Tribunal or Tribunal. What is NCLT? National Company Law Tribunal or Tribunal. What is NCLAT? National Company Law Appellate Tribunal. Appellate Tribunal or Tribunal. And then we have the Supreme. Correct? That's where you file a case. NCLT. Not happy with NCLT? Not happy with NCLT? Not happy with Supreme Court? That's it. You cannot do anything against a Supreme Court. Supreme Court is the court of last. Correct? Only the matters out of Companies Act. If you have property dispute, you go to civil court. Only if there is a disputes out of 470 sections of Companies Act, then you go to the NCL, National Company Law. Correct? Yes or no? There are total how many sections in Companies Act? 470. How many chapters? How many schedules? Some or the other ways you're gonna deal with these 470 sections in all three levels of your CS. By the time you finish your CS, you will be complete. You'll be studying all 470 sections of Companies Act. How many sections? 470 sections, 29 chapters, 7 schedules, and we also have the company's rules. And once you become CS, you can appear in the NCLT representing your client. You can present your case before the NCL because you are the expert in companies. For example, let's say there is a dispute, there is a case filed against your company. You can appear and defend your company. It's a CS. And you don't need any law degree for that. CS is sufficient to appear in the NCL case. Got it? And you will be appearing in ROC also. You should know what is ROC. For example, let's say ROC issued some notices against your company. You are the one who liaison with ROC. As a company secretary, you represent your company. You go and talk to the ROC. You explain him what is the issue. There are cases where you need approval of RD. You want to convert your company to other type of companies. You appear before RDs, regional directors. Take their permission for conversion of company. And that work is done by whom? By the CS. Getting it? Yes or no? So you must know what is ROC, what is RD, and what is NCLT, what is NCLAT, what is Supreme Court. As I said, you're gonna study all these things again in detail at the next level. We are just discussing the basic concepts of companies. And I have not yet started your syllabus. We're only discussing the word concept, basic concepts of companies. I'm putting the base for the companies so that you can understand the chapter well. Clear with this, everybody? Now, let's start with the few concepts of Companies Act which you guys already know. I will ask questions to you guys with an example you guys should answer. Can you guys answer? Let's start. Listen, everybody. Concentrate. Let's say there are two parties, okay? X Not two parties, three parties. X, Y, Z. They want to start a business. And a what? Business. These three of them wants to do business together. I will ask questions. Everybody must answer. They want to do some business. Who wants to do business? X, Y, Z want to do a business. Business. Tell me how they can do the business. Is it possible for them to go for sole proprietorship? Can they go for partnership? They want limited liability. Can they go for partnership? Okay, limited liability partnership. They want to raise the funds from outsiders. Go for what? Company. So, do you have an options to do the business? Do they have any options to choose the form of business they want to do? Yes, they can either choose the form of organization. Form of what? Organization. They can choose the business form of organization. Can they go for sole proprietorship? No. Can they go for partnership? Possible, not possible. Possible. Can they go for limited liability partnership? When they go for company, yes, they can also go for company. Depending upon advantages, depending upon your requirement, you choose what type of company you want. Sorry, what type of organization you want. And there are certain advantages of disadvantages of the various types of organization. Private company, there are certain advantages and disadvantages. Partnership, it has its own advantage as well as disadvantage. Got it? Yes or no? Now, as we are discussing the company side, let us say they decide to go with company. Go with what? Company. Now, you guys tell me what type of company they can start. Can they go for public company? Yes or no? The answer is no. Why? Because you need minimum 7 members. How many members? 7 members. Only how many are there here? Three. So tell me what type of company they can start. Can they go for one person company? Because there are how many persons here? Three. So what advice you will give them if they are your client? Go for what company? Private company. Okay. They are starting a private company. Think and answer. Everybody must answer. They are going for a private company. What company? Private company. What is the private company name? X Y Z Private Limited. This is the company name. If they want to do business, obviously they must contribute money, right? Yes, no. Without money, how the company will function? Yes or no? What is the purpose for which they want to start this company to do what? Business. Now the second question is, can they start company for charitable activity? Can we start a business? Sorry, can we start partnership firm for business purpose? Yes. Can we start partnership for charitable purpose? No. Partnership is always for business to make profit. But can we start a company for charitable activities? Yes, possible. We have company with charitable object, Reliance Foundation, Tata Foundation, Infosys Foundation. These are company with limited liability. And what is their object? Charity. Infosys is a business, like Infosys for profit purpose. Infosys Foundation is different. Tata is different. Tata Motors is different. Tata Steel is different. Tata other companies are different. There are so many Tata companies. Tata consumers are different. Getting it? Yeah. So generally, companies are formed for what purpose? Business purpose. And what is the object of business? To earn the what? Profit. So now these X, Y, Z. How many are there? X, Y, Z. They want to start a business. Obviously, they should invest the money. Right, right. Now let's say Mr. X is giving, he want to invest 1 lakh. Can he invest 1 lakh? He can invest how much ever he want. Who cares? Correct, right? Now, why he also want to invest? He should invest. He is investing 2 lakh. Z is also investing the money. He is investing 3 lakh. Total how much? Total how much? Totally X, Y, Z are investing how much? 6 lakh. Can I call this 6 lakh as a capital? Who is giving the capital? To whom they're giving this capital? To the company. When they give this capital to the company, they expect something in return from the company, right? Correct. Now, yes or no? So now what company does for this investment, company gives a proof saying that this capital they will divide it into units. Divide into what? Into units. Into certain number of units of equal value. What value? Equal values. Let's say they are dividing this share capital into a equal value of 10 rupees. How much? 10 rupees. If I divide this 6 lakh capital into equal value of 10 rupees, how many units I'll get? How many units I will get? RS 6 lakh divided by 10, cancel 1 0, it becomes how much? 60,000 units are there in the company. Company divided this into how many units? 60,000 units. These units are called as what? Called as the shares. Called as what? Shares. And this 10 rupees is called as what? Face value. What value? Face value. Got it? And the capital, this capital of 6 lakh rupees, because we taking this capital by giving shares. By giving what? Because they are given 6 lakh rupees of capital, we are giving 6,000 rupees of share in the capital of the company. What capital of the company? Share capital of the company. Now this 6 lakh rupees is called as share capital. What capital? Now the question is, sir, why it is called as share capital, sir? Because it is mobilized by issue of shares. Issue of what? Who is issuing the shares here? XYZ company. If X has given 1 lakh rupees worth of capital, tell me how many shares he should get. Don't think too much. How much? 10,000. Simple question, sir. He get 10,000 shares. How many shares? 10,000 shares. How many shares Mr. Y gets? 20,000 shares. How many shares Mr. Z gets? 30,000 shares. Are they owners of the company? Are they owners of the company? Yes. To what extent? 10,000 shares. Resanu. Who are the owners of the company now? XY Z. XY, is he holding share? Is X is holding share? Y is holding share? Z is holding shares. How many shares X is holding? Y, Z. What is the value? Value. 6 lakh. What is the value? 6 lakh. What is the number of shares? What is the face value of each share? 10 rupees. Because they are holding shares. Who are holding shares here? X, Y, Z. I want answers from you guys. Because they are holding the shares, holding what? Shares. They are called as what holders? Shareholder. What holder? How many shares they are holding here? 10,000, 20,000, 30,000. So who are shareholders? One who is holding shares. Called as what holders? What is a share? Part of the share capital. Part of what capital? A share in the share capital. Share in the share capital of the company is called as what? Share. What is share capital? A capital can be share capital as well as debt capital as well as some other capital also. Out of all this capital, what is share capital? The company can have capital. Company need capital, right? Yes or no? Capital can be share capital as well as debt capital. You take the debt by issuing debentures or by taking loan from the bank. But you take share capital by offering what? Shares. So tell me what is share capital? Capital which is mobilized by issuing shares is called as what capital? Share capital. Capital is different, share capital is different. Repeat. What is different? What is the difference? By issue of shares. Shares. Share capital is mobilized by issue of what? And what is share? What is the share? Share in the share capital of the company. Part of share capital. Who are shareholders? One who holds the are called as what holders? Is debt capital and share capital. Both are capital. Are they both capital? Yes. But what is the difference? Share capital is mobilized by issue of what? Shares. And share capital owners are the one who is holding the shares are considered as what? Owners. But the one who has given the debt capital are considered as the creditors. Considered as what? Creditors. And the shareholders are also called as members. Also called as what? Or creditors are called as members of the company? Or creditors are called as members of the company? Yes or no? No. Only who are called as members? What holders? In our example, who are the shareholders? X, Y, Z. Do we call them as members? Yes or no? Now, this share capital can be classified into two types. How many types? Everybody, how many types? Two types. There are two types of share capital, sir. The share capital can be equity share capital. What share capital? It can be an equity share capital or it can be what share capital? Preference share capital. Both is what capital? And both the shareholders are considered as what? Members. Yet the difference between equity share capital and preference share capital is that equity share capital will be having what right? Voting right. What right? Equity shareholders will have the voting rights. Preference shareholders will not be having the what? No voting right. More important, name itself indicates they are a preference share capital, means it will be having a preference over which capital? Equity share capital. It means if company wants to pay dividend, they must pay it to whom first? Preference shareholders. Then it can pay it to whom? Equity shareholders. And if a company want to repay capital first, repay capital first, they should pay it to whom? Preference. Then they can go for whom? Equity. What is preferential capital? The capital which has a preferential right. What right? What is preferential priority? Over which capital? For what? Payment of dividend, repayment of capital. When a company paid dividend to the equity shareholders without paying it to the preference shareholders, no. But pay it to whom? Then pay it to whom? If company want to repay capital, first pay to whom? Then pay it to whom? Equity shareholder. But both are what? Yes. And the holders are considered as what holders? Shareholders. And they are considered as what? Members. The owners of the company? Yes. Debt capital is different. Share capital is different. What is share capital? Capital mobilized by issue of shares. Who is shareholder? One who is holding the shares. Who is member? Shareholders are the members. Then shares will be equity shares, preference shares. What is the face value? The nominal value of the shares. Now, how many shares Mr. X is holding? How many shares Y is holding? How many shares Z is holding? 3,000 shares. Are we clear with this, everybody? Yes or no? Now, company got how much share capital? In our example, company got how much share capital? Share capital. When I say capital, it means capital. When I say shares, means shares. Shares are units, not capital. 6 lakh. How much? Can company do the business with this 6 lakh? Yes. They can also borrow money from the creditors by issuing debentures or from the bank. With that, they do the business. Correct, right? Who does the business? XYZ company does the what? Business. Yes or no? They make the they do the business, and with the business they earn the profit. Right, right. Now tell me, company is a natural person, artificial person. There has to be some individual or human brain who manages the company. Correct, right? Yes or no? There are how many members here? Three members. So members will not manage the company. Members are different, and the one who manages the company is different. Notes. Referring to the notes in mobile phone. No. Members are different, and the one who manages the company is different. Now there are three members in this company. How many members are there? Three. Wherever more than one member is there, if they want to make some decision, they should come together. Agree with this? Resa, no. If only one person is there, I can make decisions on my own. But if there are more than one person, obviously they should come together, take decisions. Right, right. So when these members come together, who comes together? Members. When the members comes together, who comes together? Members comes together to make decisions. We call it as what? Meeting. Call it as what? Meeting. So when people come together, it is called as meeting. And the meeting of who? Members, is called as what meeting? Called as the general meeting. What meeting? General meeting. So what do you mean by general meeting? Meeting of who? Directors or members? The meeting of the members is called as what meeting? General meeting. And members includes what shareholders? Equity as well as preference shareholders. Got it? Yes or no? Now the members come to the meeting here. These meetings of the members can be classified into two categories. How many categories? There are two categories, sir. First one, it is AGM. Second one, it is EGM. First of all, what is general meeting? Meeting of whom? Members. Is called as what meeting? It can be of how many types? There are two types, AGM and EGM. AGM is compulsory for every company. It happens once in a year. Once in a what? Year. And today is the AGM of Reliance company. Reliance Industries Limited is holding its AGM the last financial year today. AGM is mandatory. And AGM happens how many times in a year? Once in a year, like annual, like anniversary. Happens only once in a year, right? Yes or no? Other than AGM, every other meeting of the members is called as what? EGM. What is EGM? Very good. Extraordinary general meeting. Other than AGM. Other than what? AGM. Every meeting of the members is called as what? EGM. What is AGM? The meeting of the members, which happens how many times in a year? Once in a year. That is called as what? AGM. And any meeting of the members other than AGM is called as what? EGM. And this classification is there only for the what meeting? General meeting. What meeting? General meeting. Understood, everybody? Clear with this? General meeting can be of how many types? Two types. What are the two types? AGM and EGM. What is AGM? Happens once in a year. What is EGM? Other than AGM. It is called as what? AGM. Extraordinary General Meeting. In the meeting, if the members want to make decision, there are how many members here? Three. How they make decisions are? Decisions are made. What is made? Decisions are made in the meeting. Decisions are made in the meeting. Decisions are made by passing a resolution. Passing what? Resolution. Passing what? Resolution. Now the question is, what do you mean by resolution, sir? The members of the meeting should pass the resolutions, and these resolutions can be of two types. How many types? How many types, everybody? Two types. What are the two types, sir? It can be ordinary resolution. Ordinary resolution. Second one is what resolution? Special resolution. Special resolution. Now tell me what is an ordinary resolution, sir? I'll discuss. Now, what is resolution first of all? Decision made in the meeting. What meeting? It's called as what? Resolution. Called as what? I repeat. Decisions taken in the meeting of the members are called as what? Resolution. Can it be ordinary resolution? Can it be special? Now, what is the meaning of ordinary and special resolution? It depends upon how many votes are required. Pass ordinary resolution. You need more than 50% of the vote. How many votes? It means the number of votes cast in favor of the resolution. Number of what? Votes. The number of votes cast in favor of the resolutions are more than the number of votes. It is number, okay? NO means number. Number of votes cast against the resolution. Cast against the what? Then it is called as what resolution? Ordinary resolution. Simple majority. More than 50%. If one say yes, two say no. Or if one say no, how many should say yes? Two should say yes. Pass that resolution. Now in our company, there are how many members? Three members. How many shares are there? 60,000 shares. One share is equal to how many votes? One vote. One share is equal to how many votes? One vote. There are total, in our example, there are total how many votes are there? 60,000 shares are there. There are 60,000 voting rights. Agree with this, everybody? So, how many votes should be in favor of the resolution to pass that resolution as ordinary resolution? 30,000 plus should be in favor of the resolution. If 30,000 plus, let's say 30,001 in favor of the resolution. Favor of the what? Resolution. What happens to resolution? Resolution is passed. Means decision is taken. Then it is called as what type of resolution? Ordinary resolution. Then comes special resolution. In case of special resolution, the number of votes cast in favor of the resolutions are three times. How many times? Three times the number of votes cast against the resolution. Cast against the resolution. Then it is called as what resolution? Special resolution. If one say yes, three should say, sorry, one say no, three should say yes. Pass it as what resolution? Special resolution. Means how many votes are required out of 60,000 votes? How many we need in favor? 20,000. Ingamma, 20. How many I need? 3 is to 1 and raised to. Array 3 is to 1 and raised to 3 by 4 Allah. What is 3 by 4? 75%. What is 70% of 60,000 notes? How much? 40. Ayyo, this is 10 standard math. Not even 10 standard math. What is 1 is to 3? Sorry, 3 is to 1. Can I say 3 by 4? Array, can I say 3 by 4? 3 by 4 means how much? 3 by 4 ಅಂದ್ರೆ ಎಷ್ಟಮ್ಮ 2 by 2 by 4 ಅಂದ್ರೆ ಅರ್ಧ 50%. 3 by 4 ಅಂದ್ರೆ ಎಷ್ಟು 75%. What is 75% of 60,000? Thank God. My God. Finally. 45,000 votes should be in what? Favor. And it can be 15,000 against the resolution. Then what is passed? Resolution is passed. To pass resolution as what resolution? Special resolution. Ordinary, more than 50%. Special resolution, not more than 75%. That's it. Is it more than 75% here? No. 3 is to 1. Andre 75%. It can be more also. But what is the minimum votes are required? 75%. Then it is called a special resolution. Now the question will come to you. Like, sir, in what decision, what resolution is required, sir? Correct, alva? Question might pop up in your brain thinking like, why, in what cases we pass what type of resolution? But you will not decide. Law will decide. Companies Act itself provides for what type of decision you need to pass what resolution. It says you want to shift registered office within the same city, town, or village. You go for board resolution in the board meeting. If you want to shift it from one city, town, or village to other city, town, or village, then you pass special resolution. You want to alter the capital clause of MOA, pass ordinary resolution. You want to appoint directors, appoint whom? Pass ordinary resolution. Means simple majority. Who itself prescribes the resolution? Law. Which law? Companies Act. Accordingly, you pass resolution to take decision. Understood? So, what is general meeting, everybody? Is the meeting of whom? How many are there? What is AGM? What is EGM? It's called as what? EGM. And there are how many types of resolution? There are two types: ordinary and special. Now, this company want to appoint directors. Appoint whom? Because they cannot manage the. There should be somebody to manage the business, right? Yes or no? Are they supposed to call the meeting? Yes or no? Can be what? AGM or EGM. In the meeting, what they will do? Pass the resolution. Now they want to appoint. Who want to appoint? Company wants to appoint. Who want to appoint? Company wants to appoint the directors. Company wants to appoint directors. Appoint whom? Directors. Who are directors? The one who manage the company. Are called as what? Director. They want to appoint Mr. X. Is he a shareholder? He want to act as a director of the company as well. Can he act as a director of a company? Yes. They also want to appoint, let's say, one more person. Who is that one more person? They want to appoint. They want to appoint. They want to appoint one more person, a girl. They want to appoint even Nirmala Sitaraman ji as a director of a company. Ayyo. Why, Papa? She's a very good. I'll take some other name. Give me an actress name. Rashmika Manjana, somebody. They want to appoint her also as a director of a company. Is it a public company or private company? We need to have only minimum two directors. Public company, three directors. They are going with two. One is shareholder, other one is non-shareholders. My question is, can a shareholder be a director of a company? Can a non-shareholder be a director of a company? Arey, sir, no. To appoint these directors, you need to pass what? Resolution. Let's say we also appoint one more person, Rakshit Sethi, also as a director of a company. And we also appoint one more person, Vijay also as a director of a company. Can a private company appoint more than two directors? Yes, maximum 15. Maximum how many? 1 5. Beyond the 15, you should pass special resolution. 15 pass what resolution? Ordinary resolution. Beyond 15, you pass what resolution? Why, sir? Why? Because if you are appoint more directors, you should pay more salary, right? Take more number of members approval. Means more votes are required. So they passed OR, ordinary resolution, ordinary resolution, ordinary resolution, ordinary resolution. There are how many directors in the company here? Individually, they are called as what? Directors. Called as what? Director number one, D1, D2, D3, D4. Together, all these board of directors are considered as what? Board of directors or the board. Together, all of them are called as what? Board of directors or the board. Are we clear with this, everybody? Yes or no? Again, in the board, are there any more than one person? In the board, how many persons are there? And more, wherever more than one person is there, if they want to make decision, they should come together to discuss and make decision. Correct, right? Again, these people also do meeting. Also do what? Meeting. Who does the meeting? Director. The meeting of the directors is called as what meeting? Called as the board meeting. What meeting? Board meeting. And in the board meeting, you pass what resolution? No. In the board meeting, there is only one type of resolution called as the board resolution. What resolution? Board resolution. And the board resolution requires simple majority. The majority means out of four, how many should agree? Huh? You get majority. Three should agree. How many should agree? Three. Out of how many? Four. That is how resolutions are passed. Now, what if in the meeting only three are present? How many should agree? It depends upon how many votes, how many are present, and how many of them are voting. Who is absent? I don't take him into consideration. Only the person who is present. For example, company is having 5,000 members. Out of only 1,000 are present. Out of 1,000, only 500 vote. We only consider those 500 votes. Out of total number of votes cast, because voting is not a mandatory. It is a right available to you. If you don't want to exercise it, you can remain absent. So out of the total number of valid votes, how many are in favor, how many are against it. That is how we decide the resolution is passed or not passed. Got it? In the board meeting, you pass what resolution? Board resolution. In the general meeting, you pass what type of resolution? Two types of resolution, ordinary or special. This ordinary resolution, where the number of votes cast in favor of the resolution exceeds the number of votes cast against the resolution. It is called as the ordinary resolution. What is special resolution? Resolutions are three times the number of votes cast against the resolution. It's called as what resolution? Special resolution. In the board meeting, you pass what resolution? What resolution? Board resolution. General meeting you pass what resolution? Ordinary or special resolution. Got it? Now we have the board to manage the what? Business. Are board of directors owners of the company? Are these board of directors owners of the company? Huh? Who is the owner of the company? Shareholders. Are they owners of the company? No. They are the one who manage the company. They are the brain of the company. What of the company? Brain of the company. Because company is an artificial person. Huh. Huh. He is acting in two capacity. One as a owner, one as a director. When I say director, he's not an owner. When I say shareholder, he's a owner. So when I say directors, our directors are considered as owners? No. Our shareholders are considered as owners? Yes. Got it, everybody? Yes or no? Now company got the funds. How much funds they got? 6 lakh. With that 6 lakh, what they will do? Business. When they do business, when they're doing what? Business. Who is doing business here? XYZ company. And the company does the business. Company does the what? Business. When you do business, do what? Business. Will you make any profit? Will company make any profit? Yes. This profit belongs to whom? Company, not the owners. Out of this profit, the company can keep some amount of money for its future expansions or diversification. So, out of this profit, some part of the money can be given to members as a what? Dividend. Remaining part is kept for the what purpose? Future purpose. That is called as reserves. Called as what? Reserves. If company makes a profit of 500 crores, it can give 50 crores as dividend and remaining 450 crores can go to the reserves. And when a company is paying dividend, tell me out of this dividend amount, first they should pay what dividend? Preference dividend. Or what dividend? First to the preference shareholders, then to whom? To the equity shareholder. When shareholders demand dividend, no. Only who can give the dividend? Company. And when I say company, who manages the company? Board of directors. Board of directors. It's a complex structure, right? Directors are there, members are there, companies there, there will be shares, there will be debt, there will be loans, there will be borrowing, there will be business activities. Don't you think there should be a system to govern all these things? Otherwise, directors will do whatever they want, shareholders will do whatever they want. There should be some system, right? Yes or no? Govern everything. We have certain documents which contains the rules. Okay, so we have one document or document, one document called as MOA. Sorry, AOA. What is it? AOA. AOA provides the regulations for the management of the company, internal management of the company. Which document provides the to manage the internal affairs? AOA. Got it? And there is one more important document which says the boundary within which company is supposed to function. One more important document. That is the one more important document is this is MOA. The document MOA, which provides the scope of company. What of company? Scope of the company. To govern all these things, there is one more document. To govern what? All these things. There is one more document called as what? Called as the Companies Act. Which Act? Companies Act, which is common for all types of companies. Companies Act 20. The company carries on the business as per which document? MOA, AOA. MOA and what? AOA. And you should frame your MOA and AOA within the framework of which act? Companies Act. MOA sets the boundary and AOA provides the rules and regulations for the management of it. Are we clear with this? We have MOA, AOA, as well as the Companies Act. There will be transfer of shares, transmission of shares. There will be diversification of business. Company provides loan, company takes loan, company conducts the board meeting, company conducts the general meeting, how the meeting should happen, where it should happen, how it should happen, when the board meeting should happen, how many should be present, how the voting happens, how the shares are transferred, how the shares are transmitted, how company can take money from the public, how company can provide loans, how company can wind up the business. All these things are governed by the Companies Act. That Companies Act. That is nothing but 470 sections. It's all about companies. All about what? Companies. I hope you guys got a vague idea of what company is all about and how the company functions. The one who holds the shares are called as what holder? Are they called as members? The share capital by issue of shares. Can there be how many types of share capital are there? The two types, equity and preference. Which one has voting right? Which one has preferential right? Preference shareholders. Who are the owners of the company? What shareholders? Equity shareholders are the considered as owners of the company. Tell me, the meeting of the members is called as what meeting? General meeting. There are how many types of general meeting? What are two types? AGM and AGM. What is AGM? Annual general meeting, which happens once in a year. What is EGM? Extraordinary general meeting. In AGM or EGM, you pass how many types of resolution? Two. The two types of resolution, ordinary and special. Which one requires special majority? Special resolution. What is board meeting? Meeting of board of directors. In board meeting, what do you pass? What resolution? And that is simple majority. Got it? Yes or no? With these, we are done with the basic concepts of companies act. So, post break, we will discuss specific topic one by one, whatever is there in the material. Got it? We'll discuss provision by provisions once we return after the. We have the study. You have the study material, right? ICSI study material. I will also provide the study material. This is the CSR study material. This is how the material looks like. There are 5 chapters which are already ready. This is your material which you will receive it. Okay, which I have simplified it. Remaining 2 chapters will refer it from the material. If possible, if I find some time, I will provide the notes even for those chapters as well. If not, then you should manage with that material. It is similar to that one, only the presentation is different. Done. So post break, we'll start with the chapter. We will discuss in detail one by one. You can take a break now. You should be back exactly by 11 o'clock. 11:01. Everybody should be back to the class. Then take a break. Okay. Chapter number 2. You can make a running notes. Whatever I write on the writing pad, you guys can copy it. Chapter 2. Elements of company law. As I have mentioned earlier, in the CSEET level, You are going to study only the basic concepts of all the laws. You don't study things in detail. Especially for the Companies Act, you study the remaining topics, remaining section numbers in the CS executive level. But you should know the basic concepts so that you can build your knowledge of law strongly at the CS executive level. Done. So, elements of company law. First, we should start with introduction. In the introduction, we will understand what is a company. What is a company? What do you mean by company for you guys? The word company is derived from the Latin word. Which word? Indian word or Latin word? Latin word. It is the word company is derived from the Latin. Consists of two words. It consists of two words. Com and panis. Com and panis. Now, what is com, sir? Com means together. What is panis means what? Bread. So it is originally means the persons who took the meal together. What is the meaning of the word company? Originally means the persons who took the meal together. That is the meaning as per the Latin. The word company is derived from which word? Latin word. Com and panis. Com means together. Panis means what? Bread. But now it's an association of persons who does the business together. That is what called as company means. That's a general meaning. What meaning? General meaning. So if you see the present application of the present meaning of the companies, we can call something as a company only if it is incorporated. Only if it is what? In our example, we have taken an example where there were two members, not two members, there were three members. And if these three members want to do a business in the form of company, wants to do what? Business. These three-person can do the business in the form of company. And if they want to start a company, want to start what? Company. They want to start a company for the purpose of doing business. They can start a company only by way of incorporation. Only by way of incorporation means this business must be incorporated. It be what? Incorporated. Once it is incorporated, it becomes a what? Company. Becomes a what? Company. So what becomes a company? The persons becomes a company. So you can start a company only by way of what? Incorporations. Only by way of what? Incorporations. And these incorporations can be done. What can be done? Incorporations can be done. There are two laws. How many laws? Two laws. What is the first one? Either it can be done as per the Companies Act. Which Act? Companies Act 2013 or any other laws. What laws? Any other law or under a special act. Under a special act. Special act of the state or the parliament. When you start a company as per the Companies Act, it is called as the normal company. And if you start a company as per the special act, they are called as the statutory corporations. What corporation? Statutory corporations. Have you heard about statutory corporations or companies? Example LIC. Example what? LIC is not formed as per the Companies Act. It is also a company. Do you agree? Is LIC is a company? Everybody is LIC is a company. Yes. But LIC is formed as per which act? LIC Act 1956. There is a separate law under which LIC has been established. We have SBI, State Bank of India. It is also a company, but it has been established under the separate act of the parliament called as the SBI. So when a company is incorporated as per the separate act of the parliament or a state, it is called as statutory corporation or a statutory company. But most of the companies are formed as per which act? Companies Act. For example, Reliance Industries. What industries? Reliance Limited is formed as per which act? Companies Act. Earlier we had a Companies Act 1956, but now we have which act? Companies Act 2013. Both are considered as the companies. So if you start a company today, as an individual, if you want to start a company, you start a company by registering under which act? Companies Act. Companies Act which year? 20. So we can call something as a company only if it is incorporated or only if it is registered. And that registration can happen either as per the Companies Act or under a separate act of the parliament. And that option is available only for the government company, not for the normal companies. Got it? Yes or no? So now tell me, what is company? It's a company. It's incorporated, which is what? Under which act? This act. Companies Act 2013 or any previous company. We had Companies Act 1956. Even those are also called as what? Companies. Either you could have formed under the existing Companies Act or under the previous Companies Act. That is when you are called as the company. Called as what? What is company? Company which is incorporated under this act or any previous company. Got it? Yes or no? And there are few companies which are established under a separate act. They are called as the statutory companies or statutory corporations. Are we clear with this, everybody? Yes or no? Now you see, once company gets incorporated, once what is incorporated? Company get incorporated. Company becomes a body corporate. What corporate? Now what is body corporate, sir? All these persons together. Once they start a company, all these persons together becomes a what? A body corporate. What corporate? Body corporate. And the word body corporate are the corporations. The word body corporate is also derived from a Latin word. The word corporation. The word is what? The corporation. The word corporation is derived from which word? Again, from the which word? Everybody, Latin word. And what is that Latin word? Latin word called as the corpus. What do you mean by corpus? Corpus means what? Body. What does corpus means? Body. So the corporation word is derived from the Latin word called as corpus, and corpus means what? Body. Is company is a body? Yes or no? It's a what body? Body corporate. What corporate? So once a company gets incorporated, all the members will be considered as what? Body corporate. What corporate? Are you guys clear with this? Yes or no? So you guys tell me, what is company? A company which is incorporated under this act or any previous company law. Is there any other option to become a company? Yes. That is if it is established under a separate act of the parliament or the state. It has to be incorporated. It has to be registered either under the Companies Act or under the law made by the parliament. Got it? Yes or no? Yes or no? The word corporation is derived from which word? Latin word. What is that Latin word? Corpus. Does it mean body? And the word company is derived from which word? Latin word. And there are two Latin words, com and panis. What is com? Together. What is panis? Bread. It was originally means an association of persons or individuals who took the meals together. Got it? So company is registered or unregistered? Company means group of people, right? Is it registered or unregistered? If it is registered, it is called as company. If it is unregistered, it is called as partnership or associations. Here also there are group of persons, right? Yes or no? But is registration of partnership a mandatory or optional? Optional. But company comes into existence only by registration or only by incorporations. So if it is registered, company, unregistered, partnership or any associations. Got it? This is the meaning of the company. If you ask me the definition, as per section 22, section number what? 2. As per section 2, clause 20 of the Companies Act, company means what? Company means, what is company, guys? Company which is incorporated under this act or any previous company law. We can call an association or a group of persons as a company only if it is what? Incorporated. Under which act? Companies Act. Which act? Which year? 2013. Or under the old Companies Act, 1956. And if the company is formed under the separate act, they're called as what? Statutory corporations. What corporations? Now there are two words here. I want everyone to focus. There are two words here: company and body corporate. What corporate? Body corporate. Are they both same or different? I want answers from you guys, response from you guys. Are these words both same or different? Company is different, body corporate is different. Now, what is the difference? You can call something as a company only if it is formed as per which act? Companies Act. But you can call an association or a group of persons as a body corporate if they're having a separate legal entity. What legal entity? Separate legal entity. The word body corporate includes. The word body corporate includes what? It includes a company. Includes what? Company which is incorporated outside India. It includes companies incorporated. Company what? Incorporated. Where? Outside India. Where? Outside India. Nothing but foreign companies. Even they are called as body corporate because they have separate legal entity. It also includes companies incorporated in India. Companies incorporated where? In India. It also includes even LLP. Even what? LLP. What is LLP? Limited liability partnership, because it also has separate legal entity. The body corporate, separate from the members or separate from the partners. It also includes even the LLP incorporated where? Outside India. Incorporated where? Outside India. All these are called as body corporate. So can we say all body corporates are not companies? Yes or no? Can we say all companies are body corporate? Are all companies body corporate? Because they have separate legal entity, they are distinct entity from the members. Are all companies are body corporate? Yes or no? But all companies are body corporates are not companies. Then which companies are called as companies? Which is registered under which act? Companies Act 2013 or under any previous company law. Now tell me, Amazon company. Is it a company as per Companies Act? Is it formed as per the Companies Act? It is formed where? Outside India. It's a foreign company. What company? Foreign company. Is it a body corporate? But is it a company? Why no? It is not registered under which act? Companies Act. See, Companies Act is applicable only for the companies which are incorporated under the Companies Act 2013. They hold the AGM as per the Companies Act, board meeting as per the Companies Act. But if the company is formed outside India, why will it hold AGM as per the Indian Companies Act? It is a body corporate. What corporate? Because it has what legal entity? Separate legal entity. All companies are body corporate, but all body corporates are not companies. Are we clear with this, everybody? Reliance company. Is it a company? Is it a body corporate? Is it a body corporate? Amazon, is it a body corporate? Is it a company? It is not a company as per the Companies Act. It is called as company. But definition is clear. What is the definition of company means? Company means company which is incorporated under this act or any previous company law. Unless until you are incorporated under the Companies Act, you are not called as company. The purpose of Companies Act. Got it, everybody? Yes or no? Can partnership firm be called as company? Why no? It is not registered. For which act? Only when you are registered as per the Companies Act, you are called as what? Company. Is partnership firm is a body corporate? Partnership firm is not a body corporate. LLP is a body corporate. What is LLP? Limited liability partnership. It has separate legal entity and distinct existence from the company. Are you guys getting it? Yes or no? So we have discussed few concepts in the definition of company. First of all, the word company is derived from the which word? Latin word. What are the two Latin words? Com and panis. What is the meaning of the word com? Together. Panis means what? Alright. What does it mean actually? Sir, LLP is not legal in India. No, LLP is legal. LLP can be, we have LLP, limited liability partnerships. We can start a LLP, limited liability partnership. Done. But it has to be incorporated under the LLP Act. Got it, everybody? What is the meaning of the word corporations? Body. Correct, right? Corporation word is derived from which word? Latin word. Called as what? Corpus. What is the meaning of the word corpus? Body. Once a company is registered, all the persons are considered as a body corporate, and that body corporate is separate from the members, and it will have its own existence. What existence? Own existence. Are you guys clear with the definition of company? Now you guys tell me what is company? Company which is incorporated under which act? This act or any previous company laws. Are we clear with this, everybody? Now let us discuss the features of company. What are company? Features of company are the characteristics of the companies. First one, your favorite topic, the features of the features of the company. What is the first one? What is the first feature? What is the first advantage of a company? Limited liability. Before that, can we say a separate legal entity? Can we say a corporate personality? What personality? Corporate personality. Who has the corporate personality? Who has the corporate personality? Company has the corporate personality, and company is different from whom? Members. Company different from whom? Members. If you see, listen, everybody, listen, listen, listen. Before I go to the features, let us briefly discuss what is there in the material. Chapter number 2, elements of company law, meaning and characteristic is the first topic. What is the meaning of the company? The origin of the word company is derived from which word? What is the meaning of the com? With or together. They can ask, what is the meaning of the word com? They can give two options. With or together. What does panis means? Right. What is original meaning of this company? Association of persons who took their meal. Who took the meal what? Is called as what? Company. Originally it was called as company. What is the modern meaning? Association of like-minded persons. What persons? Form for what purpose? Carrying the business or undertaking. What is the objective of company? Earning the profits. Can we form a company for charitable object? Yes, we have discussed it, but you cannot start a partnership firm for charitable object. But company can be formed for what purpose? Charitable purpose. Are you guys clear with this, everybody? And there is a case law, Smith versus Anderson. In this case, it was held that a company in a broad sense may mean an association of individuals. Association of what? Form for a specific purpose. It is called as company. Types of companies. They can classify the companies based on incorporation into two types. What is the first one? Incorporated company. Second one, unincorporated companies. What is the first one? Incorporated company. Second one, unincorporated company. What do you mean by incorporated company? Distinct from who? Members. Unincorporated companies are just an aggregate of individuals. They don't have any separate legal entity. For example, partnership firm does not have what legal entity? Separate legal entity. Only a registered company has what legal entity? Separate legal entity. Next one, what is the meaning of the word body corporate? No incorporations. All the persons becomes a one body, right? Nothing but called as the companies. Is it an artificial person? Company is a what person? Why it is called as artificial person? Because it is created by a process other than natural birth. Company comes into existence by incorporations or by registration. By incorporations, correct, right? Next one. How incorporation happens? It can be done either under the Companies Act or under the Special Act. What act? If you form a company under the Special Act, they are called as what company? Statutory corporations. What corporations? Correct, right? Now, what is the definition of company? It's or any previous company law. Which section number defines that? Section 2, clause 20. Are we clear with this, everybody? Yes or no? These are the This is the meaning of company. What of company? Meaning of company. Now we should discuss the characteristics of a company. What is the first characteristics of a company? Separate legal entity or corporate personality. Understand the concepts first, then things becomes easy for you guys. Listen, everybody. Listen, 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 listen. The concept of corporate personality was decided. Was what? Decided in the first case, the very first case called as what? Solomon versus Solomon Private Limited. Listen, what is the company name? I will give the facts of the case. You guys should tell me what will happen in this case. First of all, do you guys know what is partnership? What is partnership? What is partnership? Definition of partnership. Tell me what is the definition of partnership. Wow. He says 19 and you say 32. Very good. What a coordination. Are you sisters by any chance? No? Okay. Uh, then continue. According to Partnership Act 1932. Continue. What is partnership? Oh, according to Section 4. Wow, very good. You're adding section numbers. They mentioned the act name, she is mentioning the section number, and you will tell the definition, is it? No. You will only tell the definition. Yeah, tell me definition. What is partnership? Something act. Yeah, very good. Right, something. Partnership is an association. Listen, it's an association of two or more persons who have agreed to share profits of the business carried on by all or acting for all. Yeah, yeah. You guys are like confirmation. Correct. You are correct, sir. Correct, correct. I know I am correct. Correct, correct. It seems. You should remember this. You are the one who is going to write examinations. It's an association of persons who are agreed to share profits of the business carried on by all or any one of them acting for all. See, in a partnership, it is always the business partners. That's right. Let's say if X, Y, if they start a partnership firm, what firm? When I say partnership firm, what does it mean? X and Y together called as what? Firm. Whenever I use the word firm, it means who? Both X and Y. If I say firm is liable, who is liable? And who is liable? Both X and Y is liable. When I say partner, it means who? X. When I say partner, Y, it means Y. When I say partnership firm, it means who? Both X and Y. If a firm has taken a loan from the bank, who is liable to repay it back? X and Y. Because firm means both X and Y. Because they don't have separate legal entity. But in the same way, what if let's say X and Y start a company? XY starts a company. Let's say XY starts a company called as XY Private Limited. If X and Y start a company called as XY Private Limited, what limited? XY Private Limited. You tell me the law creates what? A separate legal entity. What legal entity? Separate legal entity. When I say XY Private Limited, it doesn't mean X and Y. It is altogether a different person. And who created this person? No, It is not a creation by natural process. Ayyo. It is not a, it is a creation of law. What of law? Creation of law. Law is the one which creates the company, not the individuals. Is it a person? Company is a person. Yes. What person? Artificial person. Who created it? Who created it? You are just incorporating it. That's it. But who creates it? Law. Because law says it is a separate legal entity. It is a separate legal entity. That is a what person? Artificial person. Different from whom? Members. If I say company has taken loan, who has taken loan here? Company. And who is liable to repay it back? Who is liable to repay it back? Company. Not supposed to use mobile phone. If I see anyone using the mobile phone in the class, I'll confiscate it and I'll never return. You can file a case against me in the court. Recover it. And only for any emergency situations or purposes you can take my permission, then you can use it. Correct now. These are the basic principles everybody should follow. Correct, right? Because if you use the mobile phone, what is the use of coming to the class? You concentrate, participate. Then because if you deviate for even 1 or 2 minutes, then it becomes difficult for you guys to understand the topic. Yes or no? Then I don't expect anyone to use the mobile phone in the class. If you get any call, emergency call from the parents, we can go out and talk and come. No chatting in the mobile phone, no texting in the mobile phone, and no scrolling in the mobile phone in the class. If you want to do that, don't come to the class, sit at home and do it. Clear? Okay. Hmm. Now, X and Y formed a company called as XY Private Limited. Company is different, members are different. Do you agree with this? Yes or no? Who creates the company? Who can wind up the company? Law. A company created by law can be dissolved only by the law. And company has what legal entity? Separate. Company is a separate legal entity. Am I saying just an entity or legal entity? Because who creates it? Law creates it. But there is no separate legal entity in case of what? Partnership. In case of partnership, partners and firm is what? One and the same. When I say firm is liable, who is liable? Partners. When I say company is liable, who is liable? Not the members, not the what? Members. Because members are different. Members are different. Company is different. Understood? Yes or no? This differentiation between the company and members is called as corporate personality or separate legal entity. Now tell me, between partnership and company, who has corporate personality? Who has the corporate personality? Company. Who has corporate personality? Company. No partnership firm has corporate personality. Is it different from the partners? Is partnership firm different from the partners? Is company different from the members? Yes or no? Company is different. Members are different. Members are what? Different. This concept of separate legal entity was held in one of the famous case law, English case law called as Solomon versus Solomon Company Limited. What limited? Versus Solomon Company Limited. Before I discuss the case law, let me discuss few more points of separate legal entity or corporate personality. Now tell me, are the company members same? One and the same or different? First point, is company and members same or different? Company is different. Company is what? Different from whom? From the members. Different from whom? Members. Agree with this, everybody? First point. Right, right. Company has what legal entity? Company is a what legal entity? Separate legal entity. Anyone has any objections for this? You agree that company is a separate legal entity? Everybody? Third one. Is company is a person? Company is a what person? Why it is called as artificial person? It is created by law. And it is created by a process other than by what birth? Natural birth. What birth? Natural birth. Now, can a company enter into a contract? Can a company enter into a contract in its own name? Yes or no? Because company is a what? Person. Company is a what? Person. Then can you enter into a contract as an individual? Yes. When a company enter into a contract, yes, because company is also what? Person. But what person? It can do all the things which human beings does, except few things. Cannot get married. But company can enter into a contract. Company can purchase the property, own the property, dispose the property. All these things are possible even for whom? Company. Because company is a what person? What person? Can the company enter into a contract with outsiders who are outsiders other than the members? Can it enter into a contract with the members? Because they are two different persons. What person? Who are two different person? Between company and outsiders. Sorry, company and members are the same or different? Who are different? Company and members. When members enter into contract with company, can company enter into contract with members? Are the same or different? Because of what legal entity? What is separate legal entity? Which says company is different from whom? Members. Company is different from whom? Can company give loan to the members? Can company give loan to the members? Can members give loan to the company? When company sue members, sue means file a case. When company file a case against the members, can members file a case against the company? Because of what legal entity? Separate legal entity. Can company borrow loan? Can it borrow loan? If company borrows loan, who is liable to repay it back? Who is liable to repay it back? Tell me, is company is the agent of the members? No. Who is agent? One who acts on behalf of the others. Right, right. Is the company is the agent of the members? No, because company is different, members are different. If tell me, if one member does something, is the other member responsible? Not responsible. If Mukesh Ambani does something, are you responsible? Not responsible. Why not responsible? He is different. You are different. If partnership firm, if one partner does something, is the other partner responsible? Not responsible. That is what called as carried on by or anyone of them acting for all. In company, there are so many members, all of your members, all of your shareholders. If she does something, are you guys responsible? Not responsible. Not responsible. Why? Because there is no agency. Resa, no. But in case of partnership firm, if one partner does something or the other partner is responsible, not responsible, responsible. If company does something, who is responsible? Company only responsible, not the members. Are you guys getting it? If Reliance company borrows loan, who is able to repay it? Are you members responsible? You are holding one share. Are you a member of a company? If you are holding one share, are you a member of a company? Yes or no? If you are a member of a company, can you file a case against the company for any frauds of the company? Yes, because company is different, members are different. Are you guys clear with this? And that is the advantage of company compared to the partnership. Corporate legal entity or corporate personality, which distinguishes the company from the members. Company is different, members are different. Got it? Yes or no? This is the first feature of a company. What is the first feature of a company? If a member is holding, let's say, all of the shares except one, his company and member same or different? Out of 10,000 shares, 999 shares are held by you. Sorry, 9,999 shares held by one person, and one share is held by other person. There are two members, private company. Is this company member same or different? Irrespective of shareholding, company is different, members are different. Because of what legal entity? Separate legal entity. And this is the unique feature of company when it comes to the partnership. So if a client come and ask you, I want a separate legal entity, don't want mutual agency, I don't want to be liable for the act of other partner. Just what type of organization? Company. If you want that mutual agency principle, partnership. This is the first feature of company. What is the first feature of company? Everybody, what is the first feature of company? Corporate personality. What does it mean? Separate legal entity. Company is different from whom? Members. Company is different from whom? Are we clear with this, everybody? Yes or no? This concept of separate legal entity was established in a classical case law called as the Solomon versus Solomon Company Limited. I want everyone to concentrate now. What is the case name? Solomon versus Solomon Company Limited. Solomon Company Limited. I will give the facts of the case. You guys should tell me what will happen in this case by applying the knowledge of separate legal entity. Are you guys ready? Can't hear you guys, especially boys. I can't hear the boys voice in the class. Are you guys ready? Are you guys ready? Boys should be like boys. Anyways, let's start. What happened? There was a person by name called as what? Solomon. Mr. Solomon was carrying a business. Carrying what? Business. He was a sole proprietor. You know what is sole proprietor? Who is a sole proprietor? Everybody. Sole proprietor means he's a person who owns the business, manages the business, and also he conducts the business of the company. He owns the business, manages the business, and he also conducts the or take the decisions of the meeting. Then it is called as what? Sole proprietorship. Single person does everything. He was carrying a business. Carrying a what? Business. What business he was carrying? He was carrying a shoe manufacturing business. What business? Leather business. Who was doing the leather business? Solomon was doing the shoe manufacturing business. If you're having a business, if you're having a what? Business, obviously there will be assets and liabilities. Agree with this? If you're having a business, there will be what? Assets as well as there will be liabilities. Correct, right? So everything was going fine. Mr. Solomon had a good amount of profit and he was carrying the business. Later, what he did, he decided to convert his sole proprietorship into a company form of organization. Solomon wanted to form a company. Is it possible for him to start a company? Yes, anybody can start a company by registration under the which act? Companies. He wanted to start a public company. What company? Public company requires minimum how many persons? 7 persons. What Solomon did, who? Mr. Solomon, what he has done, he formed a company called as what? He formed, Solomon formed a company. Who formed a company? Solomon. And what is the company name? Solomon Company Limited. It's a public company. And we know that for forming a public company, you need how many persons? Minimum 7 persons. How many persons? 7 persons. In this company, there were 7 members. Who are the 7 members here? Solomon himself. Solomon, one person. He had a wife, one wife. Solomon, wife, one more member. Then he had 4 sons. How many sons? 4 sons. कितना हो गया? 6 plus one daughter. So total, how many members are there? 7 members of the company. So they can start which company? Public company. In this public company, the company had its own MOA as well as what? AOA, Articles of Association. In this, Mr. These 4 sons are directors of the company. What of the company? Directors of the company. And Mr. Solomon was the MD of the company. Nothing but family owned business. What business? Family owned business. And who is having the control over the company? Mr. Solomon. They formed a company. Later, Mr. Solomon wanted to acquire the business. Acquire the what? Business. This company wanted to purchase the business of who? Solomon. Solomon company is different. Mr. Solomon is different. Are they same or different? Company assets are different. Members assets are different. Resa, no. Now this company want to buy the assets or buy the business of who? Mr. Solomon. Can they buy the business? Can company buy the business from the member? Yes, they can buy. But buying the business, you should pay something in return, right? Yes or no? So in this case, who sold the business? Who sold the business? Solomon. Solomon sold his shoe manufacturing business. What business? Shoe manufacturing business. To whom he sold the shoe manufacturing business? To what company limited? Solomon Company Limited. If he is selling something, will he charge something in return? Yes. Why will he give it free of cost? He asks some company to pay something in return for him. That is what purchase consideration. What consideration? Have you heard about purchase consideration? The money paid for the goods or the business purchased or sold is called as what? Purchase consideration. Now, because Solomon is giving his business, means he is giving assets as well as the what? Liabilities. He's asking something in return from the company. Company paid him purchase consideration. How it paid? Company valued the business of Mr. Solomon. That's the business of what? Solomon. The valuation was done, and the valuation was 30,872 pounds. What is the value of business? 30,872. So who should pay this money? To whom? To whom? How much they supposed to pay? 30,872 pounds. 172 what? Pounds. Now in this, they did not pay everything in cash. Can we pay consideration in the form of assets also? Yes. So what company did? Company gave him 20,000 shares. What shares? 20,000 shares of £1 each. So कितना हो गया? 20,000 pounds was paid in the form of what? Equity shares. Then it also gave 10,000 secured debentures. What debentures? Of £1 each. Means what? 10,000 debentures. You know what is secured debentures? Secured means you will be having a charge over the assets of the company. Means if the company fails to pay the money, you can take the assets of the company. If you're unsecured, you don't have any security for the repayment of debt. So Mr. Solomon got what type of debentures? Secured or unsecured? The value of how much? How much? Remaining how much is left? 8, 800 what? Um, 30,872 pounds. This was paid in the form of what? Cash. Paid in what? Cash. So totally company has paid him how much? 38,800. Sorry, it is 8,872. No, no, 872 only. 30,872 pounds was paid. By whom? To whom? By whose business? Solomon's business. Now, I hope you guys got an idea of deal. Deal done. Now, who is the owner of the shoe manufacturing business? Who is managing the business? But after some time, what happened? This company went into losses after buying the business. After buying the what? After buying the business from whom? Solomon. After buying the business from the Solomon, the company went into losses. Who went into losses? Company went into losses. It suffered huge amount of loss. Huge amount of what? Loss. Because it suffered huge amount of losses, company decided to wind up. Company decided to what? Wind up. Decided to wind up. What is wind up? Because there was no demand for the leather shoes. So he wanted to close the business. Wanted to close the business, Solomon Company Limited. So when you close the business, what you will do, you sell the assets and you fulfill the liabilities. Correct? So at the time, at the what? Time. At the time of liquidation, at the time of what? Liquidation. What is liquidation? You sell the assets and try to fulfill the what? Liabilities. At the time of liquidation, company had assets as well as what? Liabilities. Company had assets, company had the liabilities. Company had assets worth of 6,050 pounds. How much? When I ask you guys the question, everybody must repeat it. What is the assets? But it had many liabilities. It has taken loan from the outside creditors. Has taken from whom? Loan from the creditors. Outside creditors, worth of creditors. Unsecured creditors. What creditors? There were two. First one is secured creditors. Who is secured creditor in our example? Solomon. Secured creditors worth of how much? 10,000 pound. Mr. Solomon, because he has taken the debentures. Plus, there were also unsecured creditors. What creditors? Unsecured creditors of the company were also there, and they were amounting to 8,050 pounds. How much? 8,050. In total, there were 18,050 worth of liability, but company had assets worth of only how much? 6,050. Now the question is, who should get this 6,050 pounds? Who should get it? Secured or unsecured creditors? Secured, because order of priority is simple. Secured, unsecured, then preferential shareholders, then equity shareholders, if anything is left. Now, who should get the payment? Solomon should get the payment. So, liquidator, who? Liquidator agreed to make the payment to whom? To Mr. Solomon. But creditors of the company contended that they should be paid first. Who? Unsecured creditors. Their contention was that Mr. Solomon is the owner of the company. He is holding all the shares of the company. He is the MD of the company. And they contended that Solomon and the company one and the same. Because they are one and the same, Solomon is an insider. Solomon is a what? Insider. And as per the partnership principles, remember, in case of payment, settlement of debt, first you always pay to what creditors? Outside creditors. Then you pay to what creditors? Inside creditors. First you pay the outside creditors, then you pay the partner's loan. Yes or no? That was the contention by unsecured creditors. But Solomon filed a case against its own company, stating that company is different, members are what? Different. And here, the Solomon is the creditor of a company. He's not an insider, he's a what? Outsiders. Because once a company is formed, company is different. And the court held that who is entitled for the payment? Solomon. Because he is the what creditor? Secured or unsecured? Secured creditor, and he's an outsider to the company because company is different. Remember, what if it's a partnership firm? Who gets the payment? Outsiders get the payment. Therefore, it is paid to whom? Partners. Are we clear with this? In case of company, who are considered as outsiders? Members are also considered as what? Outsiders. Because what legal entity? Separate legal entity. What is separate legal entity? Company is different from what? And the court held that. Who held that? Court held that. Court held that Solomon is different from what? Solomon is different from what? Solomon Company Limited. And who will get the payment? Solomon is entitled to receive how much? Receive the payment of how much? 6,050 pound because he is also an outsider. Can he sue the company for recovery of this if it is not paid? Yes. Because again, company is a what person? Different person. This is what happened in the Solomon versus Solomon Company Limited. He filed a case against his own company and he got the payment of money. Cash. Because we have assets only worth of 650, right? We get the payment. If he gets the payment, they don't, don't get the payment. SFL is only getting the part payment, right? Money will not get any payment from the company. This is what happened in which case law? Solomon versus Solomon Company Limited. So you guys tell me what is the unique feature or the first feature of company? Company is different from who? The same or different? Sure. I'll give an example. You guys should tell me what will happen in this case. Okay, listen. You are members of the company, not you. You three are members of the company. One, two, three are members of a company, a private company. What company? Arey bolo, what company? She is a director of a company. You are also director of a company. She is an outsider. You are managing the company affairs. Company is having various secret informations. Data is there, assets are there, computers are there, and so many assets of the company are there. Who is managing these assets? Directors are managing the assets, and you both are also members of the company. Got it? Now, we have something called as criminal misappropriation of property. What is criminal misappropriation of property? If you misuse someone else's property intentionally, it is called as criminal misappropriation or criminal breach of trust. What breach of trust? Criminal breach of trust. I make payment of taxes. I contribute some amount of money as a PF out of my salary. And if you misuse it for personal purpose, punishable, not punishable. I asked you to make a payment of, you're a CA. I give payment, I give money, asking you to pay the taxes. But you use it for personal purpose. Punishable, not punishable. Because you breach the trust. I have entrusted some property to you, trusting you, but you broke the trust. Punishable, not punishable. So the concept of breach of trust will arise only when it something is entrusted by other person. I am giving the asset to you because I am trusting you, and you misuse it, then you become punishable for criminal breach of trust. Clear with this? Yes or no? So what are the essentials for criminal breach of trust? Entrustment of property by one person to, if there is no entrustment of property, there is a question of breach of trust and they're not punishable. Yes or no? There is no question of criminal misappropriation of your own child because he's your child. Nobody has entrusted that child to you. Yes or no? If you take away your, if you take your kid for a walking or for some other reasons, is it called as criminal breach of trust or criminal misappropriation of property? No, because he's your own kid. What if you take away someone else's kid? That is considered as what? Criminal breach of trust or misappropriation of property. Now, in this case, what happened? The director of a company, what of a company? These two misuse the property of the company. Means they stole all the data of the company and they taken some computers of the company for personal purpose. Tell me, are they punishable for the criminal breach of trust? Who trusted whom here? Trusted company. Company trusted whom? Director. The company directors same or different? Was there any entrustment of property? Who entrusted the property? To whom? To whom? Did they misuse it? Are they punishable? Yes or no? But that is not the case in case of partnership firm. In partnership firm, it's a civil offense, not a criminal offense, because there is no breach of trust over there. In case of partnership firm, the property belongs to whom? Partners. There is a separate legal entity. You both, you all three are partners. You misuse the property. Misuse the what? Property. It's a civil breach of contract because it is an arrangement between the partners. Correct, right. But if it is a company, company has given the property to whom? Directors to manage it. There is an entrustment of property. And if you misuse the property, it is considered as what? Criminal breach of trust. Are you punishable? Not punishable. Because of what legal entity? Separate legal entity. Because there is an entrustment of property by the company to the directors or the members of the company. There you cannot say members and the company are not the same. And in case of partnership firm, it is what? Same. There is a question of criminal breach of trust over there because nobody is entrusting the assets to whom? Nobody. Arey, sir, no. Property of company belongs to company or members. Because company is different. If a member misuse property of the company, punishable, not punishable. If it is a partnership firm, what if a partner misuse the property of the partnership firm? Is it punishable for a crime? No. Breach of contract. What of contract? It is a civil case. Because there is no separate legal entity, there is no trust, there is no entrustment of property by one person to another person. The question of criminal breach of trust will arise only when one person trusts you and entrusts the property to you. You guys getting how this concept of separate legal entity applies in the practical world? Yes or no? Our company and members one and the same or different? Yeah. Even if 100% of shares are held by one person, still it is considered as what? Different. That is the unique feature of company. Company is different, members are different. For the act of company, who is responsible? Company or members? Because company is different, and that is called as separate legal entity. Corporate personality. If I have given a loan to the company, against whom I can file a case? You three started a company called as XYZ Private Limited. I have given a loan to the company. If I want to recover the loan, against whom I should file a case? Company or members? Can I sue you individually? Why no? Loan was given to whom? This company person. What person? If it is a partnership firm, can I sue partners? Because firm means partners. What's the difference? This is the first feature of company. What is the first feature of company? Corporate personality. What personality? Let us go to the material, and with the help of the material, we will discuss it. I will not read it. You guys should read it on your own. I already marked the important points. Read it. If you want me to explain anything, I will explain. Read first one. Read जोर से पढ़ाई करो. Read. Incorporation gives the company. What gives the separate legal entity for a company? Incorporation. No incorporation, no separate legal entity. Done. First point. Second point. They are also called as members. Clear with this? Second one. Third one. Because company is different, members are different. Fourth point. But however, having common cell is not a compulsory now. You can it is optional. Earlier it was mandatory, but now it is what? Optional. We will discuss that later. Next one. Property of the company is different, property of the members are different. Because it is a legal entity. Got it? Yes or no? Next one. Next one. Why it is considered as artificial legal person created by law. Next one. Own the property, incur the debt, borrow money, open bank account, employ a person, enters the contract, sue and be sued. Company cannot do all these things because company is a what? Person. What person? Next one. Owners of the what? Company. They are considered as owners of the company. The extent of shareholding. Next one. Can he be a member? Can a shareholder be a member of a company? Yes. At the same time, can he be a creditor of a company? Can he also give a loan? If he give a loan, he becomes what? If he gives a loan, he becomes what? Creditor. Can he be a creditor? Can he be a member? If member can play both the role at the same time because company is different, members are different. Next one. We already know this. Company is different, members are different. Next one. This also we know. Next one. Shareholders are not the agents of the company. Means if you do something, is the company responsible, not responsible? You are a member. You do something. Company responsible, not responsible? Because you're not agent of company. But partner is agent of the firm. If partner does something, who is responsible? Firm is responsible. Got it? Next one. Fine means what? Make company responsible to their personal act. But can partners make the firm responsible for their personal act? Yes. Next one. They do not hold any property as an agent or trustee of the members. Right, right. Because property of the company belongs to company, not the members. Got it? Next one. If company has given loan, who can file a case to recover it? Company, not the members. Are you guys getting it? If company has given loan, only who can file a case to recover it? Company. Because company is different. If I have given loan to the company, I can recover it from whom? Not from the, because it's a what legal entity? Separate legal entity. Next one. Can sue only whom? Because of what legal entity? Separate legal entity. Next one. Doesn't matter. Whoever it's holding it is. Company is different. Members are different. Company is different. So now we have two members here. This is the company. What is the company name? Meow Cafe Private Limited and Black Cat and the Pink Cat. The Black Cat and the Pink Cat, DC and TC, are the members of the company. Is this Meow Cafe and the Black Cat and the Pink Cat, are they both same or different? Because in between them there is a wheel, a corporate wheel called a separate legal entity. What legal entity? If Meow Cafe takes the loan, who is responsible? If these people takes a loan, who is responsible? Only they are responsible. Because of what legal entity? Are we clear with this, everybody? What is the first feature of company? Corporate personality. And have I discussed this case law called as Solomon versus Solomon Company Limited? There were how many members in the company? Seven. Who was that? Solomon, Solomon's wife, S1, S2, S3, S4, and the. Arey, where is daughter? Her daughter is missing. There was one daughter also. Okay, she is the daughter. So totally, how many members were there? Seven members. Who won the case? Solomon. It was 38,872. Okay, it is not 80,000. 8,000 pound extra was there. Who won the case? Solomon won the case. Are we clear with this? Next one, limited liability. What liability? In case of company. In case of what? Arey bolo. In case of what? Company. The liability of the members is limited or unlimited? I want everyone to concentrate now. Limited liability. In partnership firm, in a partnership firm, liability of the partner is it limited or unlimited? Partnership firm, very good. Who said limited? In a partnership firm, liability of the partners is it limited or unlimited? Limited. Partnership, it is different. Company, it is different. Company. It is not limited liability. I'll change the heading. It is liability. In case of partnership firm, I want everyone to repeat with me liability. Okay? Liability. In case of partnership, what ship? Partnership. What is the liability of the partners? The partners will have unlimited liability. Are they personally liable or not liable? Liable. If a partnership firm suffers the losses, even their personal assets are also responsible. Let's say X and Y start a partnership firm, they suffers huge loss in the business. Can the bank or the creditor recover the money from the assets of the partner? Yes, we can ask them to give everything what they have, their jewelry, their dresses, not dresses, cash, all properties, whatever they have. And of course, the liability is what? Yes or no? Are the personal assets of the partners responsible for the liability of the partnership firm? Yes. When it comes to company, what? Am I audible to you guys? Then repeat. When I say what, you should repeat it. In case of company, what? Company. The liability of the members. What? Liability of whom? The liability of the members. I didn't ask you to repeat now. The liability of the members can be of three types. How many types? And I'll ask questions at the end. First one, it can be limited by shares. Limited by what? Shares. Second one is what? Limited by guarantee. Limited by guarantee. Third one is what? It can be unlimited. You choose what type of liability you want when you start a company. Law gives you three options. Because why, if you are a company, you can choose either liability limited by shares or by guarantee, or you can go for unlimited liability. Most like you don't find unlimited companies in practical. Either the company is limited by shares or limited by guarantee. Now, what is company limited by shares, sir? See, in both the cases, liability of the members is limited. But in case of limited by shares, the liability of the members, what of the members? The liability of the members in all the cases, both the cases, in case of guarantee limited by shares, it is limited to the extent of what? Extent of unpaid value of shares. Unpaid value of what? Shares held by the member. Held by who? That is the only amount you are liable to contribute. Once you contribute the full value of shares, are you liable to contribute? Not liable to contribute. Not liable to contribute. What is the liability of the members in case of limited by shares? Limited. Extent of what? Unpaid value of the shares held by the members. For example, let's say there is a company. In that company, Mr. X is holding 10,000 shares of 10 rupees each. Out of 10,000 shares of 10 rupees each, he has already paid 5 rupees. What is the unpaid value? What is the unpaid value? 5 rupees. How much company can ask from him? What is the only liability of Mr. X now? 5 rupees. And this money can be asked at any time of the company. Who can ask this money? Who can ask this money? When it can ask it? Anytime. By passing board resolution. You can ask the member to contribute how much? 5 rupees. Mithanu, when company has more than 5 rupees, if company has more than 5 rupees, the members can throw stones at the company. Because the liability is what? Limited. The what value? Unpaid value. Arre, what value? Even if company is having crores of liabilities, still your liability is limited to the extent of nominal value. Means once you contribute the nominal value of shares. 10 rupees, 10 rupees. Once you contribute 10 rupees, you're not liable to contribute any amount after. If it is limited by shares. Then comes limited by guarantee. Limited by what? Guarantee. Now, what is limited by guarantee, sir? It's a company which is where liability is limited to the extent of what of extent of amount of guarantee. Amount of what? Amount of guarantee undertaken by the members. Undertaken by who? Members. Only girls are writing in the class. Why not boys? Boys are intelligent boys, is it? You guys are not maintaining any notes. Boys, guarantee undertaken by the members to be contributed, to be contributed to the assets of the company. So the what of the company? Assets of the company, assets of the company during the winding up. During winding up. Now listen. Now the provision says, see, we generally mention the liability of the members in the memorandum of association. Which document? Memorandum of what? Association. If it is a limited by shares, we mention the number of shares. If it is limited by guarantee, we mention what? Limited by guarantee and limited by shares. I was saying something. Memorandum of association. In the what? Memorandum of association. Either it can be limited to the extent of unpaid value of the shares. Listen at it. You have an option to choose two things. Either you can go for limited by shares or you go for limited by guarantee. Both the cases, members' liability is limited. But in case of limited by shares, members should contribute the unpaid value of shares. Limited by guarantee, the member should contribute guarantee amount. Limited by shares, member will say how many shares they will purchase, they should pay that amount of money. Limited by guarantee, they will not buy the shares. They'll say, I will contribute this amount of money. And a company goes into liquidation. For example, she says, I will contribute 1 lakh. She will say, I'll contribute 1 lakh. She will say, I'll contribute 2 lakh. What is the guarantee she has given to the company? And where she mentioned this guarantee amount? MOA. And company can ask how much from her? How much from her? How much from her? Because that is what they have agreed to contribute. And that is the guarantee they had given to the company. Can company ask more than 1 lakh? More than 2 lakh? Why no? Their liability is limited to the extent of amount of guarantee given in the what? Memorandum of association. Company might be having so much of liabilities. Still, company can ask only the amount guaranteed by the member. Yes or no? But the one major difference between these two is that guarantee amount can be called only during the liquidation. Till that time, you cannot ask the member to contribute any amount of money. Share capital amount can be called whenever the company wants. But guarantee amount can be called only during what? Closure of company. Now the question will arise in your mind, sir, why will company ask money at that time when company is closing the business? Pay creditors. Now one more question will come to your mind. Sir, what company will do during the existence of company? How they will run the business? If there is no share capital, or if there is no capital by the members, how company will run? Company will run with a borrowed capital or company will run with the donations and grants. So generally, company with charitable object. What object? They go for company limited by guarantee. So they don't need capital. But if it is a normal company, manufacturing companies or service companies, They go for which type of company? Limited by shares, because they need capital. They want to raise the capital. If I'm starting a company limited by guarantee, means if I'm going for a charitable company, do I need any capital? Do I need any capital? No. I will run with donations. Grant. Yes or no? That type of company go for what? Limited by guarantee. Limited by what? But if you're having a business for the purpose of earning the profit, you go for what? Limited by shares. So you guys tell me, in both cases, is the liability of the members limited or unlimited? I want everyone to answer my questions. In both the cases, is the liability is limited or unlimited? Where it is limited to the extent of unpaid value of shares. Limited by who can ask that money? Who can ask that money? From whom? In case of limited by guarantee, what is the liability of members? Guaranteed amount. What amount? Where it is guaranteed? In memorandum of association. Can it be called during the existence of company? Can it be called during the winding up? How much can be called? Amount guaranteed. Who can call that amount? From whom? When? During? Who can call unpaid value of shares? Array, who can call unpaid value of shares? From whom? From whom? When? What time? What time? Anytime. That is the difference between limited by guarantee and limited by shares. And you choose what type of liability you want for a company. And you mention it at the time of incorporation of company. And there is one more company called as what company? Unlimited company. There is one more concept called as unlimited liability. Now, in case of unlimited liability, what happens to the liability of members? There is no limit. There is no what? On the liability of the members. On what? Liability of members of the company, then it is considered as what? Considered as a unlimited liability. Generally, you don't find unlimited liability. I have few questions to you guys. Is the liability of the members limited or unlimited in unlimited company? If you choose the liability of the members as unlimited when you start a company, is the liability of the members limited or unlimited? Everybody limited or unlimited? Sure. Who can ask that money from members? Company or outsiders? For example, let's say there is Mr. X, Mr. Y, and they form an unlimited company. What company? Unlimited company, where the liability of the members is unlimited. This company has taken a loan from whom? SBI Bank. Which bank? SBI Bank has given a loan. A loan of how much? Loan of let's say loan of 3 lakh rupees. Tell me, who is liable to make and company incurred loss? Company is in what? Losses. Assets are not sufficient to pay for this. And company is going for closure. Company is going for what? Winding up. Who is should liable to contribute this money? Are members liable to pay this 3 lakh? Yes or no? Why yes? Who can ask that money from whom? Can SBI ask directly from the members? Why no? What legal entity? Separate legal entity. Their liability may be unlimited. That is only towards the company. Outsider does not have any right to ask the money from the members because the promise was made to the company, not to the bank. Separate legal entity. What legal entity? Company can sue who? And creditors can sue who? Recover how much? 3 lakh. And company will recover it from whom? And this can be done only when company goes into liquidation. The liability of the members becomes unlimited only when company goes into what? Liquidation. At that time, company can ask the members to contribute without any limit because it is an unlimited liability. What liability? What is unlimited liability? There is no limit on the what? Liability of the members. But who can ask the money from members? Only who can ask. Why? Because separate legal entity. How much company can ask? Whatever the liability is there. But if it is limited by shares, members are liable to contribute only to the extent of what value? Unpaid value. Once that shares are paid up, are they liable to contribute? Not liable to contribute? Not liable to contribute. Are we clear with the types of liability? Yes or no? Tell me where the liability is limited. Which type of liability? Which company liability is limited? Limited by shares and limited by guarantee. Where it is unlimited. When it is unlimited? During the whose phone is that? We don't know. Get that phone. Aram sir. Keep it for charging. Very good. You're not supposed to, yeah. Violation of privacy. Yeah. Uh, It's good that you left it in the classroom. What if you left it in outside? Like, and mobile phone is the most important thing. It contains so many informations. Losing mobile phone is like losing what? Privacy. Yeah, okay. Not only privacy. If you lose mobile phone, you feel like you lost everything in life for a few days because it contains everything: phone numbers, contact informations, so many things. Take care of your mobile phone. It hurts you like a divorce. What a lame comparisons. Anyways, what I was discussing, liability. Is the liability of the members limited, unlimited? Uh, where it is unlimited, unlimited. Where it is limited, limited by shares and limited by guarantee. What the difference between these three? And you can choose and advise your client according to their requirement. If they want they want to start a company and they want to contribute the money only when company goes into liquidation, and they also want the liability to be limited. They can go for what type of liability? Limited by guarantee. If they want the liability to be limited and they can contribute whenever the company wants, go for what? Limited by shares. And if they want their liabilities to be unlimited, go for unlimited. Are we clear with the limited liability of the members? Yes or no? But who will choose it? Members will choose it. These are the options available to the company. Got it? This is the one more feature of the company. But is this option available in case of partnership firm? No. In case of partnership firm, the liability of the partners is what? Everybody limited or unlimited? Are the personal assets of the partners responsible or not responsible? Are we clear with this, everybody? Can you guys read these points, please? Read. You want me to explain that first point? Please say no, don't say. Second one. Why? Separate legal entity. What? Yeah, ask. Go. I already gave permission, right? There is no need to ask. Again, freedom, fundamental right. Next one. Liability of shareholders is limited or unlimited? Limited. Next one. Understood? Next one. Understood? Next one. Common sense. Next one. Next one. Understood? Now, continuing with the example. These are the members of which company? Mio Cafe Private Limited. What is the name of this member? Black cat and pink cat. They are shouting at company. What they are shouting? What they are shouting? What they are saying to the company? Company asking money from them. And what they are telling? They are telling that the liability is what? Limited. They are shouting, right? अरे ऐसा नो. Yeah. Next. Next concept. Perpetual succession. What is perpetual succession? What does it mean? What is this? Company goes on forever. Members may come, members may go, but company goes forever. A death or insanity of a member does not affect the existence of. In this case, what happened? One of the member is dead. Who is dead? Black cat is dead, and only the pink cat is left. Is the company dissolved? Will it affect the existence of company? Will it affect the existence of company? Will company continue? The legal heirs of this black cat will become the member of the company. Somebody will replace that member and company will continue because company is the creation of members, creation of law. And only who can dissolve it? Law. A death or insanity of the member does not affect the existence of the company. Both the members, after visiting the company, they were going on a bike, met with an accident. Only the black cat is dead. Is the company dissolved or company continues? What if it was a partnership firm? What happens to the partnership firm? Dissolved. Because at every time there should be minimum how many partners? Two partners. Partnership firm is dissolved, but if it is a company, company continues. Because company incorporated by law can be dissolved by law. Understood? Yes or no? Members may come, members may go, but Mio Cafe goes on forever. Because it has what succession? Perpetual succession. There are 3 points. I want everyone to read the 3 points. Read. Understood? Second one. Variation in the member. Yes or no? Because company is different, members are different. Next one. What's the creation of law? Understood? Next one. Transferability of shares. What of shares? Arey bolo, what of shares? Transferability of shares. Here, the shares are getting transferred by one member to which member? Other member. This cat is dead, and this cat is taking the shares of the dead cat. What's your doubt? What's your doubt? Huh? ಏನಮ್ಮ ಅದೇ ಏನಾಗಿದೆ ಚೇಂಜ್ ಆಗಿದೆ ಅಂತನಾ ಇದು ಡಿಫ್ರೆಂಟ್ ಕ್ಯಾಟ್ ದಿಸ್ ಇಸ್ ನಾಟ್ ಪಿಂಕ್ ಕ್ಯಾಟ್ ದಿಸ್ ಇಸ್ ಒನ್ ಮೋರ್ ಕ್ಯಾಟ್ ಇಟ್ ಇಸ್ ನಾಟ್ ದ ಸೇಮ್ pink cat is no more there in the spot. New cat came, it took the shares of dead cat. Now the new cat becomes the member of the company. This is called as transmission. He is the legal heir. He is the husband of this black cat. And if the black cat dies, case goes to whom? Legal heirs. There are no kids. So obviously it goes to the husband. Wife assets goes to the husband only, na, because no kids are there. Aresa, no. Are the shares of the company transferable? Not transferable from one person to another person. Now listen, everybody, itna simple nahi hai. See, company shares. What share? Company shares. So the next feature of the company is what? Transferability. Are the shares of the company transferable? Not transferable. Repeat, transferable, not transferable. Transferability of shares is one more feature of the company. I will ask questions to you guys. You guys should tell me whether it is transferable or not transferable. For the purpose of transferability, we can classify the companies into two categories. The first one is a private company. What company? Private company. Second one is what company? Public company. In case of private company, shares are transferable, not transferable. Transferable. They can be subjected to restriction. Subjected to what? Restriction. A private company can put restrictions on the transferability of shares. Whereas public company cannot restrict the transferability of shares. Who cannot restrict the transferability of shares? Public company cannot restrict the transferability of what? Of the shares. Shares. But who can restrict it? Private company. Is it a restrictions or prohibition? Is it restrictions or prohibition? Are these two words same and different? Restrictions are different. What is the difference? You can't do it. There can't be an absolute ban on the transferability of shares because shares are movable property transferable from one person to another person. If there is an absolute ban on the transfer of shares, such restrictions are void. We can restrict the transferability of shares by putting some condition, and that too only with what type of company can do that? Private company. Public company cannot impose any kind of restrictions. Only which company can do that? And that is the difference between private company and public. Private company, by specifying in its articles of association, can restrict the transferability of shares. But public company cannot do that. Only which company can do that? Which company? Can it ban the transfer of shares? Can it prohibit the transfer of shares? Can it restrict the transferability of shares? Only which company can do that? Can public company do that? Are the shares transferable from one person to? That is what create liquidity in the shares. What in the shares? Liquidity for the shares. And the shares can be bought and sold in the market if it is a listed company. What company? Listed company. This is the one more feature, the fourth feature of the company. What is the first one? Corporate personality. Second one. Third one. Perpetual succession. Fourth one. Transferability of what? Shares. Transferable, not transferable. Can there be an absolute ban on the transferability of shares? Which company can put restriction? Public company? No. Are we clear with this, everybody? Can you guys read this transferability of shares? Read fast. Ah, if you don't want, you can sell and then exit the company, unlike marriage. Next one. Transferable or transferable? Transferable. Private companies may only which company can import? Next one. What is liberty to dispose them? Sell them. If it is partly paid, there can be restrictions, but not the fully paid shares. Continue. What is articles here? Articles of association, and only the private company put article conditions in the articles of association. Last one. Valid or void? Valid or void? Are we clear with this? This is the fourth feature of the company. Shares goes to the legal here. It is called as transmission of shares and automatically get transferred to the legal representative of the deceased member. Nominee is the nominee. If nominee is not there, legal representative of the legal representative, nothing but family members, legal heads. Done. Okay, next one. What is the fifth point? Can you guys tell me what it is? What it is? This cat is having bicycle. Is holding shares in Meow Cafe, and Meow Cafe is having what? Car. This car belongs to whom? This bicycle belongs to whom? But this cat told this girl that that car belongs to him. Can he claim that? Just because he is holding one share of Meow Cafe, he is claiming that that car belongs to him. Is this contention correct or wrong? Why wrong? He is also owner of the company, right? The car belongs to him also, right? What legal entity? Separate legal. This car belongs to whom? This bicycle. Because you are holding a share of a company doesn't mean both company and members are same. Company is different, members are different. That is what called as separate legal. Even if you are holding 100% shares of the company, still company is different, members are different. Yes or no? And if you are traveling with your parents, who can take bus ticket for you? Can they take bus ticket on you guys? Because you are the property of your parents. Can your friend take it for you guys? No. You are a stranger. There is one more stranger. You buy a ticket for her. Can you do that? No. Wrong example. Anyways, no. That will be a problem. If she doesn't like you, then you go to the police station because she is not your property. But if she is your wife, you can take. What if your wife friend is also present? You can take in the same way. On the car, who can take insurance policy? Company. Can member take insurance policy on the company's property in his name? In company's name? Company's name? Yes, because property belongs to whom? Company, not to the members. Not to whom? Members. Are we clear with this, everybody? Separate property. What property? Separate property. Can you guys read the provision, please? Even if you're holding 100% of the shares, company is different, members are different. Next one, common seal. Company is a body corporate. If company want to authorize any of the contract, they used to use the common seal. But now, as per the Companies Amendment Act 2015, having common seal is not mandatory. Is it mandatory or optional now? Optional. What if company is not having a common seal? How the contracts are signed? It should be signed by two directors. How many directors? Or by one director and one CS. Any of these two persons signs it, then the document is valid. Because having common seal is not mandatory. If you have a common seal, see, Company is an artificial person. How can we say, or when can we say company has made a contract with us? When it is signed by the company's common seal plus two directors. If there is no common seal, two directors are by one director plus one CS, company secretary. You guys. Is it mandatory or optional? If no common seal, two are by one CS and one director. Understood? Can you guys read this, please? Company acquires legal entity, perpetual succession, common seal. Three things. They may ask this in the examinations. On incorporation, company gets how many things? Three things. What are three things? Legal entity, perpetual succession, common seal. Company doesn't have any what existence. Company is a what person? Artificial person. It's a fiction created by the law. It acts through whom? Who are those agents? Directors are the agents, right? They are the one who acts on behalf of the company. Arey, no. Continue, continue. If there is no common such contract entered by the agent, must be under the what seal of the company? Common seal. What seal? Now, what if there is no common seal? How it is signed? Authorized by how many directors? Two directors. Everybody, how many directors? Two directors. Or by one director and the one company secretary. Is common seal official signature of the company? Yes. A common seal must have what name? Name of the company must be engraved on the common seal. Only the name of the company. Got it? Do you mention anything else? No. Only what? Name of the company. Rubber stamp is not a valid common seal. Should be a common seal, should be on a steel, not on the normal rubber stamps. You would have seen rubber stamps, right? That is not considered as common. It should be a made out of metal. But that is not, as I said, now because of Companies Amendment Act 2015, having common seal is no more mandatory. It is optional. Last one. We discussed this now. Having common seal is mandatory or optional now? Optional. Understood? Arey, sir, no. This is not a common seal. It's a rubber stamp. Rubber stamp is not a common seal. Arey, sir, no. Actually, this cat is cute. Seriously, it's cute, right? Next. Now, who filed a case here? To the home. Why? Because he stole the shares of who? The dead cat. Can a member of a company file a case on behalf of the company against the other members? For the wrongs against the company, only who can file a case? Company or members? Why company? Because company is different, members are what? Different. Can a member file a case against the outsider for any wrongs? No. Only who can file a case? Because company is different, members are different. Who has the capacity to sue? Who has the capacity to sue? Company. Company being a body corporate can sue and be sued in its own name. All legal proceedings by or against the company are should be in the whose name? Company's name. In case of unincorporated association, nothing but partnership firm, it can be filed in the name of the members. Name of who? Only in case of partnership firm. But in case of company, everything should be done in whose name? Company's name. Whose name? These are the seven features of the company. What's the first one? Corporate personality. Second one, third one, fourth one, fifth one, sixth one, seventh one. These are the features of the. Understood? Okay, take a break of 5 minutes and come back. Exactly at 12:50. So we have discussed the features of the company. Now we should study about the advantages of incorporation. What happens if you incorporate a company? Same thing, whatever we discussed now, they are given the same thing as a repetitions here. What is the first one? Corporate personality. What personality? Second one, limited liability. Third one, perpetual succession. Fourth one, transferability of shares. Fifth one, separate property. Sixth one, capacity to sue and be sued. And the last one, flexibility and autonomy, where they can manage the business separately. These are the advantages of company. We'll just quickly go through it because based on this, they can ask MCQs in the examinations. What is the first one? Corporate personality. Can we read this, please? Partnership firm, no existence apart from its members. The company is distinct legal or juristic person of its member. Under the law, an incorporate company is a distinct entity. Even one man company is also different from whom? Shareholders. Section 9, important. Section 9 provides that from the date of incorporation mentioned in the certificate of incorporation, subscribers to the memorandum or other person becoming the members shall be a body corporate by the name contained in the memorandum. From the date mentioned in the certificate of incorporation, the subscribers to the memorandum of association becomes the what? Body corporate. What corporate? Separate from the members. Continue. Company is capable of exercising all the functions an incorporated company. Company has what succession? Perpetual succession. We discussed this, right? When company acquire the property, company can acquire, hold, and dispose the property. Company can contract, can sue, and also be sued. Do company have limited liability? So no. Company Act provides that in the event of winding up of a company, members shall contribute to the assets of the company as per the Act. In case of limited by shares, only what value of shares? Unpaid value of share. Nothing but entire nominal value. But in case of limited by guarantee, to what extent? Guarantee amount. What amount? The limited liability is one of the principal advantages of carrying on the business in the corporate form. Which one? Limited liability. Next one, perpetual succession. What is perpetual succession? Continues irrespective of death or incapacity of the members. Notwithstanding any change in the members, company remains the what entity? Same entity with the same privileges, immunities, estate as well as the possession. A death or insolvency of the member does not affect the existence or continuity of the company. Company continues to exist until it is what? Owned up. Members may come, members may go, but company goes on forever. All these things we have discussed it, right? Yes or no? Next one, transferability of shares. Are the shares transferable or not transferable? Are shares considered as movable property or immovable property? Is it transferable one person to another person? Which company can provide the restrictions on the transferability of shares? Can public company do that? No. Transferability encourages investment in the shares. Members may encash their shares at what time? Anytime. Shares provide liquidity to whom? Investors. They can sell and they can exit the company. Shares can be sold in the open market and the stock exchange. Free transferability of shares provides the stability to the company. It provides what? Stability. How does it provide stability? Capital remains the same. Members will change. What remains the same? Capital. Correct, right? Shares will keeps on changing from one hand to another hand, but capital remains the what? Same. That gives stability for the company, unlike partnerships. Next one, separate property. What property? Have I discussed this separate property? Is company capable of owning the funds? Reza, no. Property of the company is separate from the shareholders. And company is the real person in whom the property is vested. Property is controlled, managed, and disposed by whom? Company itself, not by the shareholders. Even majority shareholders cannot use the company property. Only who can use the property of the company? Company. Unauthorized use of the company's funds or property may amount to what? Criminal misappropriation, misuse of the assets of the company. When companies sue, can it sue and be sued because company is a what person? Artificial person. Is it liable to be sued for the dues against the company? No. Members or the directors cannot be sued. Only who can be sued? Company. Flexibility and autonomy. Company has autonomy and independence to form its own policies, but they should frame their policies in accordance with what companies act. Okay, you can frame your own rules and regulation, but that should be as per which act? Which act? Companies act. Company can implement the policies subject to the law, equity, and good conscience. Company policies must comply with which act? Companies Act. Policies must comply with the memorandum as well as articles of association. Company form a business separate ownerships from the what? Control. Who controls the company? Directors. Who has the ownership? Shareholder. So it separates both control as well as the ownership. But in case of partnership firm, has the right to manage the affairs of the company. And the last one, separation of ownership and control promotes the professional management and efficiency. What management? Because anybody can be a manager of assets of the company, unlike partnership firm. In case of partnership firm, only who can manage the partnership firm? Partners. These are the advantages of company. There are how many advantages? What is the first one? Corporate personality. Second one, limited liability. Third one, fourth one, fifth one, sixth one, and the seventh one, flexibility and autonomy. Got it? Clear with this? Yes or no? Then we have limitations of incorporation. One more theory topics, then we can discuss the lifting of corporate hill. Limitation of incorporation. Before I go to this topic, I have some questions to you guys. You guys should tell me or should answer my questions. Listen. I am your client and you are a CS, company secretary. I have few questions to ask. You guys should tell me, should answer my questions. Then listen. Um, can I start if I want to start a partnership firm? Do I need to get it registered? Is it optional? Can I just enter into an agreement and start a partnership business? But if I want to start a company, am I supposed to get it registered? With whom I'm supposed to get it registered? Under the Companies Act, with the ROC, Register of Companies. When you make an application for incorporation of company or registration of company, you need to pay the fees. You need to pay the stamp duty on the MOE. You need to pay the fees to the ROC. Fees to whom? And you should prepare various documents like MOE, AOE, declaration by members, and there are so many formalities to be complied with, and that form should be certified by a CSES or CMA within practice. These formalities are prescribed to deter the person or to prevent the persons who are not serious from incorporating the company. Incorporating the what? Companies. There are more legal formalities when it comes to what? Company compared to the partnership. Compared to what? This is one. Lot of incorporation expenses are there. Second thing, you are supposed to take the permission of ROC and RD and NCLT for various matters. You want to shift your office from one state to another state, you require the permission of RD. But if you want to shift your place of business in case of partnership firm, you don't need anyone's permission. That is the one more disadvantage. And in case of company, you every year you supposed to prepare the accounts, get the accounts audited, and file it with the ROC. Filing accounts and annual return is mandatory in case of companies, but there is no such requirement in case of partnership. Getting it? And whenever a company pass resolution, company must inform the same to whom? ROC. There is no such thing in case of partnership. And company documents are public document, means anybody can inspect it. Company's MOE, AOE can be inspected by anybody, but not the partnership. So these are the disadvantages of the company. It's the legal formalities. What formalities? So which one has more legal formalities? Company or partnership? That is the one disadvantages of company. What is the first disadvantage of company? Formalities and expenses. Compared to partnership firm, which one has more legal formalities? Which one has less legal formalities? Yes or no? When we read these points, please, I will explain word by word if you guys read it. When I say stop, stop, I will explain it. Right? Cumbersome and detailed legal formalities. Companies Act itself provides the detailed legal formalities and procedure involved. It involves time as well as the money. It takes minimum 15 to 20 days of time for incorporation of company. Got it? Partnership, no, just go to the stamp, buy a stamp paper, make an agreement, start the business. So incorporation involves expenses as well as the time, considerable time. Second one, why that elaborate procedures was given for the persons who are not serious from starting the companies. Continue. Who are not serious about doing the business as a company enjoys various facilities. Ah, continue. As per the company side, cannot go beyond the company side. Partnership is always managed as per the partnership agreement. We will discuss that and let go to the partnership. Next one, filed with a registrar of companies, some periodically and some on the happening of an event. You should file annual return. You should file accounts of the company with ROC. Again, one more compliance burden. That is not there in case of partnership. Next one, maintenance of books of accounts is compulsory for company. Maintenance of register of members, register of preferential holders, register of debenture holders is also mandatory for whom? Company. You should maintain the books as well as the registry. That is the one more expenses or formality. Next one, approval and sanction. That is the one more formality. But there is a such approval or sanctions for whom? Partnership firm. Next one, corporate activities such as corporate meetings, accounts, audit, borrowings, lending, investment, as per the which are companies. That is the one more formalities. Next one, there are penal consequences. Other form of business organizations are free from the legal complexity and procedural formality. This is the one disadvantages of company. Same thing is there in your material. Got it? Second one, corporate disclosure. What disclosure? We need to make disclosures about all the actions you take to the ROC. Right, right. It is possible that is required only in case of what? Company. There is a detailed corporate disclosures required in case of what? In case of company. In case of what? Even then, members have the limited access to the internal management. Management is done by whom? Board of directors. Who does the management? Board of directors. So the members don't have access to the internal management. And who does the internal management in case of partnership firm? That's the one more difference. Next one, shareholders cannot directly participate in the what? Day-to-day administration. When partners do, yes or no? Next one, separation of control from who are the owners? Shareholders. Who manages the company? Directors. Is there any separation? Yes or no? We do not have effective and intimate control over the working like partners in a partnership. Their partners have a direct control over the partnership. But members don't have direct control over the company. Next one, large companies, members cannot effectively control the day-to-day affairs. Who does that? Board of directors. Next, Because company is different, members are different. If member does something, is the company responsible? Not responsible. Not responsible. Next one, nor the agents of the company. Not the agents of the company. If they do something, is the company responsible? Not responsible. Not responsible. If partner does something, is the partnership firm responsible? Yes. Next one. Are they active or passive? They play passive role. They just invest the money. Next one. Then who has the control? Board of directors. Greater social responsibility. People expect company to play a huge role in the company, right? For example, Infosys contribute some of the amount of their profit to the charitable activities. Correct, right? So people expect companies to contribute or play a huge role in the social responsibilities. We have CSR, corporate social responsibilities. Correct, right? So there is a greater social burden on the companies. Can you guys read this? On the society. Companies are expected to show greater social responsibility. Next one is greater tax burden in certain cases compared to the partnership firm and sole proprietorship. Tax burden is more in case of company. Why? Because in case of individual, if you're a sole proprietor, you will be taxed according to slab rate. Let's say if your profit is up to 10 lakh, this is the tax rate 10%, more than 10 lakh 20%, more than 20 lakh 30%, like that. But in case of company, flat rate. Irrespective of your profit, you are taxable with, let's say, 25%. I'm not giving the exact rates of tax. It is fixed rate of tax in case of what? Companies. But in case of sole proprietorship business, he enjoys a slab rate. What rate? What is slab rate? 10 lakh, you get 10% of tax. That's it. If you earn more than 10 lakh, 20%. More than 20 lakh, let's say 30% of tax. So there is a tax tax on the slab basis. But in case of company, it is fixed irrespective of the amount of tax. That is the one more disadvantage of companies. So that is why usually what small business does is they go for partnership. Go for what? Then they convert that partnership firm into company. Into what? Yes or no? Can you guys read this, please? In certain circumstances, tax burden on the company is more. Company is liable to tax without any minimum taxable limit. Registered partnership firm and some other form of business enjoy the minimum taxable limit. Means they will get the tax minimum amount which is not taxable. Next one. A company pays the income tax on the whole income at what rate? Flat rate. There's no exemptions or deductions. Other forms of business are taxed on the graduated scale or slab system. Means to this is the tax. More than that, this is the tax. Next one. Obviously, if more the tax, I will not go for that type of organizations, right? So usually, partnership firm may be suitable for what? Initial stage due to the favorable implications. Business may be later converted into the company when the tax implications become more favorable due to the growth and scale operations. Next one, detailed winding up procedure. What procedure? Forming the company is expensive and time consuming. Even closing the company is also what? Time consuming. Unlike partnership firm is formed by an agreement and can be dissolved by an agreement. Understood? These are the disadvantages of company. So we discussed three concepts: company, features of company, advantages of company, disadvantages of company, or limitations of company. Are you guys clear with these? You guys have 5 minutes of time to go through your material, and if you have any question, you can ask now. Go through the material. Correct now? Common seal have I discussed? Capacity to sue and be sued. Advantages, corporate personality, section number 9 also is that we have discussed all this point. Limited liability, perpetual succession, transferability of share, separate property, flexibility and autonomy. Limitation, formalities and expenses. Done. Corporate disclosures, separation of ownership from control from ownership, greater social responsibility, greater tax burden, detailed winding up procedure. Done. Only these many topics are done. Tomorrow we will finish this chapter. Try to finish this chapter. Because most of the concepts I've already covered in the form of general discussions. Just have to go through it. That's it. Getting it? Yes or no? Now close your notebooks, everybody. I have questions for you guys. Today I will ask questions in general. From tomorrow I will ask questions individually. Yeah, shit happens. Hmm. Okay. Today's class we started with introduction to the law. What is a law? Hmm. Which one requires a bill? Which one is a delegated legislation? Rules are the delegated legislation. Who makes the law in India? Who enforces it? Who interprets it? How the laws are made effective? Fine. Damages. How the laws are made or how an act is made. Bill, Lok Sabha, discussions, argument, pass. Then act notified in the official gazette. How to read section number? First one. In case of civil cases, the one who files the case is called as plaintiff. Other person, criminal cases, state versus accused. Appeal, appellant and respondent. Then we started with the Companies Act. There are how many sections? How many chapters? How many schedules? Along with that, we have the company's rules also. Who oversees or who administers the Companies Act? Companies Act. Companies Act. Who implements the Companies Act? MCA. Under MCA, what do we have? Under RD, what do we have? Every state has how many ROC? Two ROCs. Coimbatore and got it clear. Then we also discussed dispute resolution mechanism, NCLT, NCLAT, Supreme Court. Supreme Court is the court of last appeal. No, the person who holds shares are called as what holder, and the capital mobilized by issue of shares is called as how many types? Equity and preference. Which one has preferential right? Can a company pay dividend to the equity shareholders without paying to the preference shareholders? Because they are what right? What right? Who are members? What is general meeting? Meeting of members. This called as what meeting? How many types? There are two types. Which happens once in a year? Which happens twice in a year? Any meeting other than Asia? How decisions are taken in the general meeting? By passing resolution. How many types? Are there two types? Which one requires more than which one requires simple majority? Which one requires special majority? Who appoints directors? Who appoints directors? Shareholders in the meeting by passing what? Resolution. What resolution? Ordinary resolution. Members pass only the ordinary or special resolution. Who appoints directors? Members by passing what resolution? Ordinary. To how many? 15. Beyond 15, what resolution? Private company minimum how many? To public company? Three. Three directors. Members 7. The meeting of directors is called as what meeting? What meeting? And they pass what resolution? What resolution? Can which documents govern the structure of the company? Structure MOA. Internal formalities AOA. Are they required to be drafted within the company's act? So no. Uh, is it mandatory for a company to contribute or pay dividend to the members? Is it mandatory for a company to pay dividend? No. If companies pays dividend, company members can receive the dividend. Are shares transferable? Freely transferable? Freely transferable? Yes. Can private company? This general statement. Are shares freely transferable? Private company can it put restrictions? Public company, private company by mentioning in the articles of association. Can public company restrict the transferability of shares? Can private company do it? Can it prohibit, restrict it, do liability of the members limited or unlimited? It depends upon type of company. There are how many type of company? Three. Limited by shares, limited by guarantee, unlimited company. Where it is limited to the extent of guarantee amount, can that amount be called during the existence of the company? Winding up by outsider, by company, Sano. Property of the company is property of whom? Does it belongs to shareholder? Who can take insurance policy on company property? Can members take insurance policy? Because property of company is different, property of members different. Is there any separation of control? Who controls the company? Board of directors. Who appoints board of director? Shareholders. Can shareholder also be a director of a company? Yes or no? So we have spent around 5.5 hours of time in the class. And by using this 5.5 hours of time in the class, we have discussed many things which are the basics for your other chapters or basics for learning the other chapters. Right? Do you think you are a different person now from what you were at 8 a.m. today? Yes or no? At 8 a.m., you had certain knowledge of certain things, but now you got some more informations which will help you guys. Some are the other ways in your future. That should be the attitude, that should be the goal or the object with which you guys come to the class. In today's class, some of you are zero, some of you are plus one, means some of you are already knowing some informations. To this, we have added plus one, plus one. Right? So, like this, each and every class, we should be adding some or the other information which is going to be useful for you guys in your future or in your career. It is not like you should study this only for your CS purpose. Even if you don't do CS, if you are going to do something else also, these informations are useful. The moment you enter the class, the first question should ask First question you should ask yourself is, what new thing I'm going to learn today? How many questions I will ask? How much I will participate? This is the attitude with which you come to the class, and that is why you are paid for. Getting it? Yes or no? You should not compromise with your studies. You should keep your studies as a paramount interest, and you should be regular to the class. And hardly we're gonna spend some days, a few days of time, and in these few days of time, make sure you guys learn things as much as possible, which will add to your knowledge and clear your CSET so that you can go to the executive level with confidence. You should be a different person, and you become a great person or you become a different personality by adding some information each and every day. Conceptual clarity is what most important. It is not like you learn something in CSCT and you will forget it. You will carry this information till the what? Till the time you complete your profession. And even after the profession, because these are things which you do it practically. Yes or no? Got it? So make sure and you guys be bit serious about the profession. It is not like being serious doesn't mean you sit with a serious face in the class. Being serious in the sense you'll not compromise with your object or goal, not deviate from the goal. What is the goal? You want to become a CS, you want to learn something. That is why you travel from the park places and you reach the academy, right? Once you enter the class, all the only thing you think about is what new thing I will learn today. If sir is discussing something, what questions can ask? Try to ask difficult question. Try to ask questions first of all. It can be any question. Doesn't matter whether it is silly or not, silly or whatever it is. No question is silly. First of all, to ask question, it takes a lot of courage. And getting it. So learn properly and clear the examination with good knowledge. So that will help you guys in the next level also. Done? Yes or no? So I'll see you guys tomorrow at 8 o'clock with the remaining topics of the company side. Done? Hello. Thank you. See you tomorrow.